My pleasure, Lordship. Lordship, may I mention the one rate petitions for the at least disposal with the directions to the respondent department to consider the similarly situated person, madam. The department has subsequently done in similar way, but we are exactly praying for. So therefore, this is a small matter. Pleadings are completed, and with the consent of the Standing Council for the Education Department, if possible today, madam.
Today, actually, what is the issue?
Madam.
There are 35, 34 numbers of matters already been fixed. And that apart, I have fixed one DV matter at 2.
Madam.
Because of the problem that it was a part-heard matter
Madam.
and the constitution of bench same, it again creates some problem. So that's why I fixed it on at 2 p.m.
Madam.
So today I cannot say, maybe by tomorrow.
Tomorrow, madam.
Maybe
Only
this-
small matter, madam. Just to give it to the directions to the respondent authorities.
Let it be tomorrow.
Madam.
Okay.
May I please, sir?
Yes.
I beg to mention item number 4 on behalf of DK Dury. He's not doing
DK
well.
Deori.
Yes, Lordship. He's not feeling well, so the matter may be adjourned.
He's not?
He's not well.
Oh, he's not well.
Yeah.
So he's not keeping.
I have informed the government side. So,
The
matter
government
may
side
be
has already been informed.
yes, Lordship.
With the consent of the other side, the learned counsel appearing for Mr. D.K. Deori, the engaged counsel for the petition, paid for an adjournment stating that Mr. Deori is not keeping well. They are allowed. How many weeks you need? 2 weeks will do?
2 weeks, Lordship.
Is the matter accordingly after 2 weeks.
Obliged.
My lord, I beg to mention item number 9. I, on behalf of Tagum Jamo, Standing Council of Food and Civil Supply, I am newly appointed as Standing Council. So even I have no record of this case. So matter may be listed after 3 weeks.
No, food and civil supply was earlier represented by Mr. T. Jamu.
Yes.
Now you are
But-
the newly.
Yeah. No. T. Jamo, I am my senior. Is my senior.
He
Standing
has been
Council of
newly engaged. No,
Yes.
what you're saying?
newly appointed. So we have no record of this case. So we
No
need,
record?
Yes. So we need time.
No, you're not provided with the petition also. Copy of the petition and all.
No, your.
Petitioner side is available, item number 9. Petitioner side is whether
Yes,
you are
yeah.
for item number 9.
Yes, yes.
So they are saying that you have not provided with any copy and all for the petition.
Yes, we will not provide.
You have not provided.
No.
You are Mr.
Sita Jo. April we have Deepangi.
Appear on behalf of Mr.
Deepangi.
Sita Jo, appearing on behalf of Mr. D. Panging, the learned counsel for the petition, also heard. You are Mr.
Endoji.
And Doji, appearing on behalf of Mr. T. Jamu, the learned standing counsel food and supply. And it is submitted by Mr. Doji that Mr. Jamu is newly appointed, and that apart, the copy of the petition is also not provided to the respondent side. In that context, the counsel for the petitioner is hereby asked to provide the copy of the petition during the course of the day, enabling the respondent side to file their written affidavit in opposition, if any. List the matter, how many weeks you need?
3 weeks.
3 weeks.
3 weeks.
List accordingly with the matter, 3 weeks accordingly.
Must oblige.
May I? Your Lordship, I beg to mention item 37. I'm April we have Deepangi. I'm taking consent from the other side also.
Have you informed the other side?
Yes, Your Lordship.
With the consent of the other side, the learned counsel appearing on behalf of Mr. Deepangi, paid for an adjournment. Why Deepangi is not available today?
Your Lordship, due to some personal
Personal.
difficulties.
Stating that due to some personal inconvenience, he is not in a position to appear before the prayer allowed. After 3 weeks?
Yes, Your Lordship.
List after 3 weeks.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 35. The leading counsel of this instant matter could not present today due to some inconvenience. Matter may be listed after 2 weeks.
No, it is an order column. Have you taken stage 35 to devotion? Item number 35.
Item number 35.
Because matter is fixed today and the other side is
Yes.
not appearing. Whether steps you have taken steps?
Yes, they can take it. And I took consent from them.
So name is not,
Yes, yes.
the counsel for the respondent's name is not reflected in the
Yes,
cause
yes.
list. That's why I'm asking.
Is Zitalo? Galen
Zitalo.
Talo, yes.
No, but the office notes speaks that on 4/11/2025,
Yes.
neither Bakaratnama nor affidavit in opposition has been filed on behalf of the respondents. So as per your knowledge, Mr. G. Talu is appearing.
Yes, yes. Last time he had appeared.
He appeared.
Yes, yes.
Okay. Or he was appearing through VC on the last.
Yes, yes.
So there is a question of maintainability also.
Yes, yes. Question of maintainability. So leading counsel is
Mr. Rama,
no, yes, yes, Mr. Rama. He is not attending today.
you are Mr.
Techi Itatara. Serial number 2 of petitioners.
Oh, acha. You are also TT Tara.
Yes, Techi Itatara.
আচ্ছা একটু নামটা খালি লিখে দিব না হলে গন্ডগোল হয়ে যাবে হার্ড মিস্টার টেচি টিটারা the learned counsel for a petitioner who with the consent of the and accordingly paid for an adjournment with the consent of the other side. However, it is seen that the name of the counsel for the respondent is not reflected in the cause list and it is submitted by Mr. Tara that one Mr. G. Talo had already appeared on behalf of the respondents. From the office note dated 4/11/2025 also, it reveals that the Wakalatnama is also not yet filed for the respondents. And the affidavit in opposition is also not yet. Wakalatnama as well as the affidavit in opposition is not yet filed by the SUEX. In view of this, let the matter be listed after 2 weeks, enabling the respondent to file their Wakalatnama as well as the affidavit in opposition, if any. And the registry is also hereby directed to reflect the name of Mr. G. Dalu in the cause list, in the next date of listing.
Obliged.
May it please, Your Lordship. I beg to mention item number 36, Your Lordship.
Yes,
Uh,
criminal appeal.
Yes, Your Lordship. Lordship, the conducting counsel is out of station, Your Lordship. So,
Mr.
Met-
Sonar.
yes, Your Lordship. So, matter may
The
adjourn for
matter is
3.
of 2021, but
Yes, Your Lordship.
so he is in custody. The appellant is still in jail or he is in bail. You don't have any idea.
So sorry, man.
Much. Anyway, you are Mr.
T. Dargay.
T. Targe.
T. Dargay.
So and so had Mr. So and so appearing on behalf of Mr. R. Sonar, the counsel for the appellant. And it is submitted that Mr. Sonar is not available in the court today and accordingly paid for an adjournment with the consent of the other side. Where allowed list the matter according 2 weeks will do.
3 weeks, Your Lordship.
List of the matters after 3 weeks as an additive fixed by the registry.
Obliged.
Your Honor, I would like to mention item number 29. I'm appearing for the respondent number 2. Your Honor, my senior counsel, Mr. T. Bayor, is out of station. Due to that, he could not be.
So you are for the respondent.
Yes,
Have you taken consent of the other side?
petition is there.
Your Lordship, I have an objection in this matter. Since kindly appreciate this is a fixed matter. And only
Yes, it is a fixed matter.
only the prayer of his senior, this matter has been fixed today. And kindly where is the order dated 24/3/2025? The
Item
last
number
opportunity
29.
was given in
Item
24 March itself. However, Your Honor, Your Lordship, his senior is not present today before this honorable court. So I humbly pray that this matter may be adjourned as a last opportunity for the respondent and kindly fix the matter on 17th of this month.
17 is not possible for me. My senior counsel has a matter at Basar court. So he
Then
couldn't be.
18 year.
Uh, in the next week, we'll do.
Next week, we have some personal difficulties here. So kindly,
In the next week, my senior is available for any date in the next week.
not next week. I'll be out of station next week.
My lord, in this case, pleading has been completed. The matter may be
After
fixed.
24 March 2025, they are again and again seeking time. Now today, this matter has been fixed, Your Lordship. Only at the prayer of his senior. But today itself, he's not present for his honorable court.
In the last occasion, my senior is present, was present, and
He has fixed this matter for
and
today, Your Lordship.
contempt case and IA was disposed of on the day. That's why.
Heard Mr. Ibam, the learned counsel for the petition, and also heard Mr. You are Mr. You are Mr.
PK Gore.
B.K. Gore.
PK Gore.
Acha. P.K.
PK.
P.K. P.K.
Yes.
Gore appearing on behalf of Mr. T. Bayer,
Yes. TY.
the learned and guest counsel for the petitioner or respondent, and it is submitted by him that due to some personal inconvenience, Mr. Bayer is not in a position to appear before the court today and accordingly paid for an adjournment. Post. Next, in that context, Mr. Bam, the learned counsel for the petitioner, submitted that since March 2025, the case has been fixed and the adjournment been paid on behalf of the respondent. And on the last occasion, that is on 27/10/2025, the case was fixed today at the request made by, as agreed by the counsel for the respondent. Next, considering the submission made by learned counsel for the petitioner, let the matter be. You want to fix it here?
Yes, Your Lordship, on 18th here.
It
18 will
is
do.
not possible for my senior.
Your Lordship, he said that on 17th he has a case at Basar, but 18. there is no
18,
case.
18, what will the problem?
Yes, Your Lordship.
Then 19 will do.
Yes, Your Lordship. Then 19.
19 can be because 19 is a Wednesday and where I have been told that the Wednesday, generally the DV is there.
Yes, Your Lordship.
Yes.
Okay, then, oh, sorry. Also, it is a single batch matter, sorry.
Yes.
So 19 can be, otherwise,
19.
do you have any problem in that?
Maybe fix on next week.
Next week, he has
Yes,
some
I have
problem.
already submitted. I have a.
He has already submitted, he has some.
Then my lord, up to 2 weeks.
No, Your Lordship, 19. This could be on 19, Your Lordship. He said that he has.
17, you have matters, you have already submitted.
Yes.
18, we have some problem, I think. So 19, let it be on 19,
Yes, Your Lordship.
okay?
My lord.
Accordingly, list the matter on 19/11/2025, directing both the parties to proceed with the hearing without any adjournment. List accordingly. Okay.
Right.
Much of it.
Lordship, I beg to mention item number 32, Your Lordship, on behalf of this conducting counsel at attack, Lordship. Lordship, today is supposed to be filed affidavit in reply, but it's could not, so need more time to file. Your
32 is connected with 31, in fact.
Lordship.
It's a connected matter, 31 and 32.
No, Your Lordship.
No, as per cause list, it is yes. 31, 32 devolution. It's a connected matters.
So,
You are appearing for the 32, I think,
yes.
but these, both the 31 and 32 are the connected one. 31, 32 devolution. Mr. Tatak is appearing for the petitioner in
Petitioner.
item number
32. That's
32.
WPC 633.
And the other council is appearing for the 31, but these are connected. Yes, in regards to affidavit in reply,
In this WPC 633. Or 30,
in WPC 633, affidavit in opposition is still awaited. It's not filed.
yeah.
Affidavit in opposition filed. Yes, state is also here, na? You have filed, na?
Yes, your lordship. Lordship. I'm for the petitioner in item number 31.
You are for the petition, item number 31.
This
And in
can-
item number 31, whether the private respondents have filed their affidavit in opposition here? No,
No, not yet.
not yet. Thirty-one to 32 লগত আছে, huh? Heard, you are Mr.
T Magaha.
T. Maka appearing on behalf of Mr. X. Gatti
Yati, yes, Your Honor.
for the petitioner in item number WPC 523 of 2024. And also heard Mr. MSP Sangeeta, the learned comment advocate appearing for the state respondent. 1 to 3. Respondents number 1, 2, and 3. And it is stated by her that they have already filed their affidavit in opposition on behalf of the state respondent. Also heard, you are Mr.
GT Raju.
Your name is here? No.
No, no.
K. Raju, the appearing on behalf of Mr. A. Tatak, the counsel for the petitioner in item in WPC 633 of 2023. And from the office note, it is seen that the private respondents have not yet filed their affidavit in opposition. However, it is submitted by MS Sangeeta that they have already filed their affidavit in opposition on behalf of state respondents. List the matter accordingly after 3 weeks, enabling the respondent side to file their affidavit in opposition, if any. It will be stated on after 3 weeks.
Obliged.
Much obliged.
Item number 1.
Hey, see, one matter I have fixed tomorrow for as well. But ask the list to list the matter before I go before Mr. Das, Justice Das, Ranjan Das, or before Mr. Pudi. Yes, next morning, because I don't have time. So, the mention is allowed, but maybe next week. Yes, whatever, whoever. Yes,
May I pledge allows. Here is an application under Article 226
Hmm.
for under Constitution of India seeking issuance of a writ of mandamus and or any other appropriate writ or order or direction against the impugn arbitrary action and illegal action on the part of respondent authority in wrongfully placing the petitioner on the wait list for the post of
yes,
general.
tell me one thing, while the notice, publication of notice was there,
Yes,
I mean, whether the notice, this was, advertisement was for 6 posts.
yes.
8 posts. It was for 6 posts.
It was advertisement was
For how many posts?
for 55 posts where
No,
the
out of 55 posts. but
55
here
posts
the
out of
Ayurvedic-
which I have applied for general duty medical officers post in homeopathy.
Yes, homeopathy.
Only 6 posts.
No,
so
you are
6
saying
posts.
that 8 posts are vacant, but
Yes.
but advertisement was for 6 posts only.
Yes.
Then,
And accordingly, now Your Lordship, I'm coming to that point. Before that, invitation, advertisement was invited from all citizens of India, wherein all the 55 posts for post of general duty medical officer, that is at page 27 annexure 1 by the Public Service Commission, that is Arunachal Pradesh Public Service Commission.
It is all right, yes.
So here, page 28, specifically it is mentioned at serial number, page 28 annexure 1, that is serial number 3, GDMO homeopathy. Down below is the data, that is total 6 posts. They have advertised. Then thereafter, I have participated, I have submitted my application, I have applied for the same, and I have participated in the examination. I have gone through and I have successfully crossed the written examination, and I have also participated in the Viva Voce. And I was placed at the waiting list number 1. Then thereafter, after elapsed some more than 2 months, after the result, said result, I came to know from the reliable sources, whereby the respondent number 2, number 3, this is respondent number. Yes, it is respondent number 4, that is Director of Health Service, Government of Arunachal Pradesh, Itanagar. Then when I came to know, now your may I take your Lordship at page 47, annexure 3. Then type copy is at page 38. Annexure 3, page 38. So this is the communication letter which has been issued by the respondent number 4, that is the Director of Health Service, Government of Arunachal Pradesh, wherein the subject matter, may I read the following, this. To the Commissioner Health and Family Welfare, Government of Arunachal Pradesh, Itanagar. Commissioner Health is the respondent number 2. The subject is submission / clarification on requisition for the post of GDMO, LO and GDMO Homeo, Group A gazetted to APPSC, that is Arunachal Pradesh Public Service Commission for recruitment. So here subject is also very clearly stated for recruitment. Then down below, I would like to read, sir, with reference to the subject cited above, I am resubmitting, your Lordship, kindly please note it, resubmitting, meaning there it has already been submitted previously, and this is the second time where he is resubmitting here with the requisition for recruitment of GDMO allopathy and GDMO homeopathy Group A gazetted as stated below to Arunachal Pradesh Public Service Commission, Itanagar, and indicating the reservation of so-and-so candidate as below. So here at table below, serial number 2, very specific, GDMO, Homeo, total vacant post is 8. So here my submission is that after the result was declared, I am finding my place at serial number 1 at the waiting list. Then only I came to know, then there, so this is it is very crystal clear from this communication letter. Then now, thereafter I have submitted my representation to the competent authority, respondent authority. Then my representation is at page 40. Type copy is at page 42, annexure 4. Representation for consideration of appointment against non-advertised post of GDMO Group A gazetted post.
So what's your representation now? The representation is still pending.
Yes, representation is still pending.
Whether there is any order on your representation? No.
No. Now, then
Okay.
thereafter, Lordship, I have filed one legal notice being agreed without there being any positive action from the respondent authority. Then I filed a legal notice. Legal notice is at phase 44, annexure 5, sorry. So here entire thing has been clearly stated. Then thereafter, in pursuance to this legal notice, the respondent,
Mr. Then we are just you are representing all the respondents.
My lord, I'm representing respond number 2, 3, and 4, my lord. My lord,
Lordship, I'm appearing for respondent number 5 on behalf of senior.
Senior Advocate A. Apang.
Standing counsel for
So you are 1, 2, and 3.
my lord, I'm representing 2, 3, and 4, and
Oh, sorry, 2, 3,
one
and
is
4.
state represented by
Ah,
Kobe is representing.
state is represented.
My lord,
That
Well-
means formal notice is not required, but you require some time.
my lord, yes,
Otherwise, I have
But-
seen the case.
yes, my lord. Advertisement, my lord, is limited to 6 posts, my lord. According to the 6 posts that has been filled up, my lord. My lord, this is
That is
settled.
the thing.
Yes, it's become.
And I don't know on what basis he definitely representation can be made at that. I won't say.
No issue, my lord.
But legal notice on what basis you have submitted legal notice and all that is to. Anyway, you just take the instructions and clarify these things and on the next date of listing.
My lord.
Otherwise, too, I have seen that
My lord.
case
Because
Yes, I-
appointment cannot be done beyond the advertised
beyond
post.
advertisement, it cannot.
And that's a bit, and even if assuming there's a more posts back end, madam, it's up to the authority to what post is to be filled up through a direct recruitment, and certain posts has to be kept up for promotion.
Yes.
It's not required that all the back end posts is to be advertised, madam. So it's up to the government, up to the authority, madam. So according
You
to
clarify these things,
My lord.
then you file it. You are Mr. D. Boje. I heard Mr. D. Boje, the learned counsel for the petitioner, and also heard Mr. T. Basar, no? You are Mr. MS Basar, no? You're, oh, sorry, P. Pango. Heard MS P. Pango, the learned government advocate, appearing for the respondent number 1, and also heard Mr. T. Tagum, the learned. You are standing
council for the health department, health and family welfare.
Standing Council, Health and Family Department for the respondent number 2, 3, and 4.
Yes.
And MS K. Lawyer, appearing on behalf of Mr. A. Apang, the learned senior advocate, for the respondent number 5. For the respondent number 5. The this application has been filed under Article 226 of the Constitution of India for issuance of a writ of mandamus or any other appropriate writ, direction of the order of like nature, challenging the illegality and challenging the arbitrary and discriminatory action on the part of the respondent authorities for not the authorities despite of knowing the existence of 8 sanctioned vacant posts at the time of advertisement, and only 6 sanctioned posts were advertised due to administrative lapses. Issue notice to the respondents. No formal notice is required to be served on so and so inquiry report. Full stop. List the matter accordingly. You need 2 weeks or
My lord, 3 weeks, and let a requisite extra copy also be furnished.
oh yes. Extra copy of the writ petition be furnished to the respondent site during the course of the day. Further, full stop. List the matter accordingly after 3 weeks, enabling the respondents to file their affidavit in opposition, if any. Okay, we are listing it after 3 weeks.
all right.
Deeply.
You just furnish the copy of.
Oh,
Item number 2.
May I, Your Lordship?
Yes.
Your Lordship, I'm appearing on behalf of Mr. M. Kato for the petitioner.
Hmm.
Your Lordship, I pray that we seek further 2 weeks to file affidavit in reply.
Affidavit in reply.
Yes.
Otherwise,
We have
we
already filed, madam.
so Mr. Takumi is appearing for respondent number
My lord, I am for respondent number 2, 5, 6, 7, and 8.
2, 5, 6, 7, and 8.
Yes.
And government is
1, 3, and 4.
1, 3, and
3 and 4.
third. You are Mr.
T. Meto, Your Lordship.
Heard Mr. T. Metro appearing on behalf of Mr. M. Kato, the learned counsel for the petitioner, and also heard MS P. Sankita, the learned government advocate, appearing for the respondent number 1, 3, and 4, and Mr. T. Takum, the learned your standing counsel education,
Education, madam.
standing counsel education department for the respondent number 2, 5, 6, 7, and 8.
8.
On behalf of Mr. Kato, it is submitted by submitted that how many weeks you need?
2 weeks, Your Lordship.
2 weeks time is required for the to file the affidavit in reply. Prayer allowed. Please demand accordingly after 2 weeks.
Deeply obliged.
Item number 3. Your Lordship, may pass over the matter for time being, Your Lordship.
Item number 3
Yes.
for the time being.
Yes. Item number 5.
Yes, item number 5.
Hi, my lord.
Yes.
My lord, this is relating to compensation in the construction of Trans-Arunachal Highway. My lord, in this case, landowners were paid compensation, but Solitium was not paid.
That is the only issue.
That is the only issue. And in this regard, there is a settled position of law. The Supreme Court has passed a judgment in Mihin Lalin's case that the landowners are entitled to get Solitium with interest. This is a settled position of law. So this is my prayer that your lordship may be pleased to dispose of the matter, directing the respondent authority to pay Solitium with interest to the petitioners. This is a
Mr.
judgment.
Do you want to submit here anything or it can be disposed of?
My lord, I have a copy of judgment.
Okay, sure, please. So, yes, Mr. Ratan.
My lord, their cases will not be covered now as per the judgment of the Honorable Supreme Court, because the learned single judge in Mihin Laling case held that they will be entitled to for 100% Solitium. And then even the division bench upheld that. The Honorable Supreme Court says that yes, they will be entitled, but for those already concluded acquisitions, concluded acquisition process, this will not, the solution, it cannot be reopened. These are cases filed after the conclusion of the acquisition process. Acquisition process was completed long time back. They came up, basing on Mihin Laling case, they came up and filed these writ petitions claiming for 100% solution.
My lord, this matter has been discussed at para 28 of the judgment of the Supreme Court. The matters which are pending in the court, that has been protected, my lord.
Twenty-eight,
my lord. May I read 28, para 28. Second last page. Second last page. Para 28, it says, in respect of concluded acquisitions where compensation has been finally determined, accepted and disbursed, no reopening shall be permissible. To this extent, he is right.
Now, let's see the next sentence. The impugned judgment of the High Court is therefore set aside to that extent. However, in all matters which remain pending, either before the competent authority or before a court tribunal, the compensation shall be recomputed to include solatium and interest as above. So we have been protected.
How I just now see again you read
Yes, my lord.
the first sentence is okay. No.
You're right.
And the impugned judgment of the High Court is therefore set aside to the extent. However, in all matters which have remained pending either before the competent authority or before any court or tribunal, whatever, the compensation shall be recomputed to including this solatium and the interest as well.
Yes, my lord.
But whether this case's question is that it has already been concluded, the process after the conclusion of the process, now we have come with a petition for 100% solution. Now, whether it will be entitled or not, that is the issue.
Yes, my lord. That is what I'm saying. To the extent that reopening cannot be made in which compensation had been paid and accepted.
You have not been paid now.
No, I was paid.
Achha.
I have already received. But next sentence, let us try to interpret very correctly. However, in all matters which remain pending, either before the competent authority or before a court tribunal, the compensation shall be recomputed to include solatium and interest as above. This clarifies that the pending cases, they are protected by this order. And this case is pending since last 2 years. And there is an order of this court to list the matter after disposal of the special SLP number 5662/2023.
That has already been disposed of?
The order that I have served, Your Lordship, that is the one. This is order dated 25 May 2023. So this case was pending 25 May 2023. I have extra copy, my lord.
Okay.
Sorry, एक सेकंड. ये ऑफिस कॉपी है. ये. Last page, last paragraph, my lord. Last paragraph means para 5, last subparagraph last. Though notice to the respondents have been issued in this case, this writ petition shall, however, be listed only after the aforesaid SLP number 5662/2023 is decided by the Honorable Supreme Court, which shall be brought to the notice of this court by the learned counsel for the petitioners. So this especially petition has been already disposed of, and as per that judgment, I am entitled to get solatium with interest, my lord.
Yes.
Your lordship has passed a judgment in Michi Tayan's case. ये थोड़ा देखिए तो. Reference में ना. 22. This judgment was passed by your lordship, and as per this judgment also, direction has been given to the respondent authority for payment of solatium with interest, my lord. And this judgment was passed on 22 March 23. This is settled position of law, my lord. Many more judgments are there, whereby direction have been given to the respondent authorities for payment of solution and interest. So many judgments I have of this honorable court, my lord.
Yes, Mr. Andrews.
My lord, it is their petitioner's own contention that they were already paid the compensation amount. In their notice, after receiving the, if my lord, there are series of notice annexed in the writ petition itself. It starts from, my lord, page, my lord,
50.
page 56,
Yes.
annexure 5. This,
They are notice.
yes. This is a notice by the counsel for the petitioners, my lord. What it says, that my client has plot of lands located at Nacho, so and so, buildings thereon. He has received a sum of rupees as compensation for the land and property for acquisition of his land in the construction of BRTF road, so and so. That my client is entitled for payment of solution for compulsory acquisition at the rate of 100% amount as provided under law, so and so. Similarly stated, my lord, here they have mentioned the Mihin Laling's case itself, meaning thereby after the conclusion of the acquisition process, they after accepting the compensation amount, just because in one case of Mihin Laling, the court has directed to pay 100% solution. Now they have come up saying that we are also entitled. Exactly in what the Honorable Supreme Court in this paragraph has said, already those concluded acquisition where the payment was accepted, disbursed, it will not be applicable to them. The next sentence, what my learned friend is relying on, is that any matter remaining pending either before the competent authority, it says competent authority, or before a tribunal, a court tribunal, where, my lord, this is where the quantum of compensation has not been determined. The quantum of compensation is yet to be determined. There it says the 100% solution shall be applicable. At para 28, it's a matter of interpretation. If we interpret in his line, then the meaning of the word concluded will be become redundant. What the Honorable Supreme Court has clearly said, concluded acquisition process. Now, this is already a concluded acquisition process. This has come to life only on the basis of Mihin Laling case, my lord. The judgment of the Mihin Laling case, they have started. Before that, they didn't come to the court. But to be more clear on this point also, there are 23 of this judgment.
There are 23.
Yes, madam. Of the same judgment. At the same time, we are conscious of the limits of judicial intervention. The High Court, in its impugned judgment, permitted reopening of all concluded acquisitions under the 1947 regulation. This is the Jumlena. For reassessment of compensation, such an approach, in our considered opinion, may travel beyond the permissible bounds. Finality of administrative action cannot be lightly unsettled. To do so would not only destabilize public projects, but also create physical uncertainty. Balance must therefore be struck by ensuring that pending and future acquisitions are aligned with the standards of the 2013 Act, while leaving untouched those transactions where compensation has been finally determined and accepted. Because of this Honorable Court's direction only, they have come. Now, they cannot say this is pending. the very basis on which they are claiming on this Mehin Laling case, the Honorable Court has clearly said that this will not be applicable for the concluded. In future, it will be 100% solution. And then our state has also made an amendment in the Zoomland regulation itself that it will not be less than the LARA Act, madam, the compensation. Yes, madam. In fact, they were fence sitters. They were happy with the compensation amount only just because in some other acquisition process and some other case, they claim 100% solution and then they were directed to be given. Now they have come basing on that judgment that we were also denied, but they were just fence sitters, man. They never protested before accepting. They never demanded 100% solution. Therefore, these cases were concluded cases. They will not be entitled for 100% solution.
My lord, may I explain this particular paragraph in a more wider way?
You have already.
I'll read it again, my lord. It is a bit wider that I have submitted earlier. It says, I'll read out from however. However, in all matters which remain pending, either before the competent authority. Up to this, let me explain. Even if the matter is pending before any competent authority, be it be before the deputy commissioner, be it be before the director, that comes under the pending matter. And if such pending matter is there, that is also protected. Then come to next, or before court or tribunal. The compensation shall be recomputed to include solution and interest as above. And here another paragraph is there, para 25. 25 and 26, this is pertinent. Para 25 says, my lord, in view of the foregoing discussion, we direct that the respondents shall also be entitled to solution as well as interest in accordance with provisions of the 2013 Act. This signifies that the land losers or landowners whose land have been acquisition, they are entitled to get solution, my lord. And let us see the another paragraph, next paragraph, 26. The appellant shall ensure that any areas towards solution and interest, wherever not yet paid, are released to the landowners of the subject acquisition within a period of 3 months from today. These two paragraphs has cleared the doubt whether pending matters are protected or not. It is clearly protected, my lord.
Okay. Is any other submission, Mr. Singh? You also submit anything?
Yes, my lord, but I agree, my lord. Because, my lord, judgment is, to me, my lord, is clear, my lord, that in the pending, my lord, if the, my lord, the amount has not been, my lord, quantified by the collector, the authority, then, my lord, this case, they are entitled for the, my lord, solution and interest, my lord. Otherwise, in the concluded case, my lord, it cannot be reopened, my lord. Admittedly, my lord, they have filed, as my learned friend has submitted, they have filed after the, my lord, judgment of the Mehin Laling case, my lord, which was already, my lord, pending before the Supreme Court, my lord. So, my lord, to my respectful submission at this stage, my lord, may I pray that, my lord, the deputy commissioner or the secretary land manager may come out with the affidavit, my lord, by giving all the details, my lord, when the acquisition was held, my lord, and when the payments were given, my lord, and when the acquisition were concluded, my lord. Then it will be, my lord.
But concluding of acquisition is not disputed, I think.
Not
Acquisition
It is
process
not
and
disputed.
receiving the compensation amount is not disputed.
Not
It's
disputed.
Admittedly, this is a concluded process. That is no doubt about it. And they have also admitted in notice itself, it speaks that it is a concluded amount. The
Then-
question only remains that whether after the conclusion of this acquisition process, after receiving the payments and all, whether the question of solution will rise
Yes,
or not.
yes,
That
madam.
is the only issue.
Madam, to my respectful, my submission, no, madam. It cannot be, madam.
Mr. Cartro is also appearing here.
Yes.
Same.
Another
also said
aspect of the
same.
matter is, my lord, the Mehin case was based on, my lord, a judgment of, my lord, Tarsem Singh, my lord, regarding, my lord, where it is said, my lord, in Tarsem Singh, my lord, or in all acquisition proceedings, my lord, solutions and interest has to be paid, my lord. My lord. This judgment of 2019 is under review, my lord. Recently, my lord, the National Highway Authority of India has filed a review application this month itself, my lord, before the Supreme Court, and Supreme Court has admitted the, my lord, the review application, my lord. Whether question is, my lord, whether, my lord, in a, my lord, they will be entitled for, my retrospective, my lord, claim of the compensation, solution and the interest, my lord, in a concluded proceeding, my lord.
So review is still pending before the Honorable.
Yes, madam. Only last week only it was filed before the Supreme Court, madam. I will come with those, madam, materials, madam.
Then let him come with those materials.
Let it be after, madam, 2 weeks, madam.
Okay.
Well, regarding Tarsem Singh case, had that case is pending before the Supreme Court, at the time of passing the order in Mehin Lalin's case, that could have been discussed in the Supreme Court. And this is not the appropriate forum for discuss the matter which is pending in the Supreme Court. And I am not relying only on that judgment. So many judgments are there.
No, that's what Mr. Sakia is saying, that there are one judgments wherein it is stated that even after that solution will their compensation regarding the solution will be also there. But the question is that those matters are still before the Honorable Supreme Court through an review application, review file. That is still pending, I think.
Yes.
Or he may come up with all these data in the affidavit.
My lord,
Question, what do you want to submit?
Otherwise
Matter-
also, my lord, the entire, my lord, I have shown the notice. Entire claim is based on Mehin Laling's case.
Yes, that is.
This entire writ petition also is based, relying on Mehin Laling's case in the single bench and the division bench. All the claim for 100%. It is not that because it was under the jail, my lord. Now, this, whether only the point to be decided is whether this case pending before this honorable court can be said to be a pending before what the honorable Supreme Court has indicated, pending before the authority court tribunal. The word clearly says concluded acquisition process where the compensation amount has been determined, my lord, for paragraph 28. Determined, accepted and disbursed. Concluded means they have, it was the compensation amount was determined, they accepted it, it was disbursed to them. That is all. The next sentence, what the Honorable Supreme Court means is that if the quantum is not been determined, if there is a dispute still pending, although the acquisition process initiated under the JLR, if the quantum is still disputed and pending before any tribunal, authority or court, then
it can be recomputed.
It can be recomputed because it was in it, because there is no acceptance. But here it is the case of acceptance and disburse. So it is concluded, madam. So now it is a very simply what I interpret, my lord, it's these cases will not be covered for 100% solution, my lord. That is it. It's a concluded.
My lord, regarding application of the judgment of the Supreme Court, application of a judgment will effect from the date of passing judgment, my lord. It cannot be taken back to the past. So whatever judgment is there in this judgment, whatever terms and conditions are there, that will have effect from the date of passing judgment, my lord. So going back to Mihin Ali's case, that will not apply, my lord. I pray for the disposal of the matter.
Your entire case is based on Mihin Laling's case.
No, no, my lord.
Then now you are saying that?
No, I am saying this judgment was passed on 16th of September.
Yes.
The cases which are pending before any authority or in the court before 16th September, they are protected. They are protected, my lord.
Anyway, I'll pass the order.
Similar is
And so many similar cases are there.
all item 5, 6.
हम बता देता हैं एक एक करके. Item number 5, that is the case that we have discussed. Item number 6 is similar nature. Item number 7 is also similar nature. Item number 8 is also similar nature. Item number 12 is similar nature. Item number 13 is also similar nature. Item number 14 is also similar nature. Then item number 16, no, not 16, 17. 17 is also similar nature. Then item number 19 is also similar nature. Then item number 20, item number 21, item number 22, item number 23, item number 24, and item number 25. These are similar nature cases.
All are of similar nature?
Yes, ma'am.
Similar nature.
Or concluded acquisition initiated after the initial Mihin Laling case, my lord.
All are notice are of similar like.
Yes, similar language by the council, my lord.
That means 5 is 5 plus your 5, then I was saying 5, 6.
6, 7.
5, 6, 7.
8,
8,
12,
12,
13,
13,
14,
14,
17.
15 is not there.
No, 15 is not there.
Then
16 is also
17.
not there. 15 is also similar nature. Of course, I'm not representing here. He is informing.
He is coming 15.
15.
15 to no, it is there.
Now 17, my lord.
Let forget about the 15. Then your matters are 15.
My matter 17.
15 plus 17.
17. 16. Then 19.
Plus 19.
Then 20.
Plus 20.
21.
21.
22.
22.
23.
23.
24.
24.
And 25.
These are all similar matters.
Similar nature.
These are as per you. These are all concluded.
Concluded. Initiated.
In all these cases, you are basically relied on this Mihin Laling case.
Mihin Ali case, yes, we can
Apart
say
from
Mihin
the
Ali
others,
case.
I can-
Lalu kan nama pack 16 mas dia. Lalu kan simpang ya mungkin nama.
Can pass the order.
Yes, ma'am. My lord, may
Mr. Sakya, I think that admittedly these are the concluded process, and admittedly this compensation has already been disbursed and accepted by them.
Yes.
But the question only the 100% solution is there.
Yes,
It's
ma'am.
the only remaining.
Yes. Oblige, madam.
तो सेव ही करके रखो, अभी देखता है क्या होता है. ऐसा लेके it will be again problematic to carry all this. How can we carry these things? नहीं दिखा, सेव ही रखो. हाँ, क्योंकि अभी पता नहीं ना, अभी होगी वही नहीं होगा. नहीं दिखाना, सेव ही दिखाना, सेव ही. हाँ, ऑल दिस सेव सब हार्ड करके सेव ही दिखाना. एक लाइन में सब करके ये put it all in CV. If I can complete it, then I'll pass the order tomorrow by tomorrow. But somehow, if it is not, because I'm leaving tomorrow, somehow it is complete. If it is completed, then we'll list it tomorrow, by tomorrow. And if it is, suppose in any reason it is not, then definitely I'll from the principal seat also I can. Oh, इसको सबको रखना है यार, तुम लिस्ट बना लो. 5, 6, 7, 8, 12, 13, 14, 17, 19, 20, 21, 22, 23, 24, 25. All are there. इसको भी लेके जाओ, फिर बिन बन के उसको भी दे दो. नहीं.
Item number 3. Passable matter.
My please, Lord.
Number 3 was passable matter.
Yes.
Yes.
Malad, this matter, Malad, here, though we have prayed for solution, etc., interest, and all that, Malad, we will forego all those prayers, Malad. Now, this is not exactly a land acquisition as such, Malad. For construction of this national highway from Itanagar to Bandadeva, Malad, the government decided to pay compensation to the people who are affected, Malad. This was done in 2016, Malad. Lordship, may kindly annexer 2, Malad. This would make it clear. Page 27. Married. The second May 2016, my lord. Date might not be clear, my lord. Second May 2016. Whereas there's a proposal for widening of the existing 2-lane to 4-lane dual carriageway configuration of Itanagar Bandadeva stretch of NH 415 from 31 to 40 kilometer in the state of Arunachal Pradesh. And whereas a prohibitory order was issued by the Deputy Commissioner, District Magistrate, Itanagar Capital Complex, white number such and such, dated 13/3/2014, prohibiting the construction of any new building within the approved strip plan of proposed 4-lane national highway. And whereas survey and assessment of structures standing within the proposed ROW of 4-lane national highway was carried out with effect from 17/9/2014 to 22/9/2014, white number such and such, dated 8/9/2014. Again, survey and assessment of left out structure standing within the proposed ROW 4-lane national highway was carried out on 2/10/2014. And whereas a notification was issued to the government by the government white number such and such, dated 29/3/2016, in pursuit of the cabinet decision dated 16/3/2016, that no compensation should be paid for the land or structure falling within ROW of the existing NH 415. And whereas in the view of above notification, the last list has been prepared for the structures and properties for which compensation will be paid. And now, therefore, the public notice is issued to whomever concerned on the above mentioned stretched land to file their claim and objection within the office of the Deputy Commissioner, Itanagar Capital Complex, Chandranagar, if any, by clearly mentioning the reason for such objection within 15 days from publication of notice, that is from 3rd May 2016 to 16 May 2016. No claims and objection will be entertained after the expiry of 15 days under the circumstances. The compensation assessment respect may be inspected in the office of Deputy Commissioner, Itanagar Capital Complex, Itanagar, E. Nahalagan Highway Division, Nirjuli, Extra Assistant Commissioner, Itanagar, Extra Assistant Commissioner, Nahalagan, and Circle Officer, Bandadeva, and during office hours.
Now, my lord, for that, your lordship may annexer to page, next page, my lord, 28. This public notice was issued, my lord. And now, lordship, down below, committee was formed for that one. Means there were 7 members, my lord. First, the Mr. Tame Ajum, EAC, Likin Kuyu CEO, Executive Engineer Highway, DAO Papumpare, UPIA, DHO, DFO Bandedeva, DFDO Papumpare. These were persons. This was done in 2016, my lord. This assessment. Now, lordship may kindly to annexer 4.
Yes.
Whereas public notice was issued white number such and such dated 9 April 2021, the board carried out physical verification package C. This is my my plot comes within package C. Nirjuli Bandadeva on 19 and 20 April 2021. As per physical verification carried out, board felt that the compensation amount of following beneficiary may be released. So my name comes under my lord, 295, second row. Serial number 295.
95.
Yes, ma'am. Tame Bhai. Second row, madam, down.
Yes, 295.
Yes.
Disney. Yes.
Now, madam, kindly to page 34, madam. The rest are all almost similar, ma'am. Page 34, ma'am. Annexer 7.
Yes.
It is for information to following persons whose plot will be affected due to a 4-lane construction NH4 on the package C to present at their plot for disbursement of compensation on 5th July 2021, Monday month. So my name comes down 295.
Yes.
Madam, now the respondent authorities have disbursed the amount, madam, and I was paid 80,000. Now, lordship, make only page 40, madam. That is not disputed, my lord. I've already been paid 80,000. My lord, this is the RTA information obtained from the Deputy Commissioner, Office of Deputy Commissioner, my lord. This assessment was of the we sought the assessment of 2016 assessment. What was the compensation amount that was prepared, my lord? Now, if lordship may kindly page. So, 50, my lord. 50. Last down below, the plot 551602 55180. Last row.
Yes, yes.
My name is Tame Bhai. These are the tree, RCC wall, teak, etc. My lord. This is the compensation amount that was arrived at by the 2016 my lord, board, which I have shown in Annexer 3, my lord. And the total amount, my lord, that was, if we calculate that amount, my lord, it Uh, 95, right? 95, no. 5,95,000, madam. But they have paid only, my lord, 80,000, madam. The total amount,
Have you made any representation in that regard that even after the assessment that you should get 5,95,000?
no,
You
but
will
we
receive 80,000,
file a
or you
simple
want to pay
application.
Huh?
Annexure 1, my lord, the application, we saw solution and all that, my lord, application was given. No, of course, my lord, now the stand-up, my lord, what happened, the respondent authority says because the government, they have done a re-verification of the plot, therefore, we found that those objects were not there, so the compensation amount has been reduced, my lord, to 80,000. So they based the resolution of, my lord, may come to page 60, my lord. Last annex. This is type copy of the minutes of cabinet meeting. Malak, may kindly see agenda number 5. Proposal for providing demolition costs as incentive for package B and C and payment of land compensation for construction of viaduct over River Dikrong at Kolma, Papumpare, Arunachal Pradesh. The decision of cabinet. Malak. After detailed deliberation, the cabinet approved the proposal of providing demolition costs as incentive for package B and C and payment of land compensation for viaduct over River Dikrong at Kolma, Papumpara district under 4-lane project of NH 415 with following directions. This mechanism here, compensation to be dispersed after due verification by district administration. District administration shall be solely responsible for any anomalies. In this regard, I think it is typographical mistake. It should in this regard. For demolition of structures, the policy of government on demolition package charges in package A may be applied mutandis. Land or packages to be handed over to the highway department within 7 days. Now, the first line, compensation to be disbursed after due verification by district administration. District administration shall be solely responsible for any anomalies in this regard. The cabinet wanted that the disbursement of the compensation should be done after due verification. Now taking this as one of the grounds, what the administration did is, they carried out a re-verification of the compensation amount, which was already done in 2016. In 2021, they want to say they want to do verification and find out those materials after more than almost 8-9 years. Now, government in their affidavit has said that they have done due verification was done, and they didn't find the structure. That's why the amount was reduced to 80,000 only. Now, for rejoinder, we have filed our rejoinder.
Reduced to means earlier it was for 5,95,000.
Yes.
Then it was reduced to 80,000 after re-verification.
Yes. There was no direction from the cabinet to do reassessment, my lord. Verification means to verify the person whether he is the actual owner or not. That has to be verified. They were not asked to do that reassessment. That was not the direction. The verification of the person, if the person the right person has been paid or not. That verification should be done. Now, in the name of verification, the success of the deputy commissioner carried out reassessment of the compensation. Now, Lordship may kindly take up our rejoinder. Affidavit in reply, Madam.
Affidavit in reply, page.
Here. Page, Madam, it will be starts from
It will be like affidavit in
page
reply.
60. Madam.
Affidavit,
Affidavit
different,
in
different, oh, no, yes, yes, affidavit in reply. No?
Yes, Madam.
Yes, yes, I have it.
Madam, kindly page 68, annexer 1.
68? No, 68 is there.
Lordship got. Well, the last time we were said that something was wrong, but we checked it was correct, Madam.
You're saying page number 68.
Yes, Madam.
Your
Yes.
affidavit in reply in page number?
68.
No, definitely.
68. Yeah.
We don't have any 68 page. Yes.
Something must be wrong. Last time also, Madam.
Last time also, yes, I
Yes.
have gone through the record that last time also there was some direction regarding the pagination.
So we
You have not corrected the pagination.
no, we checked, but it was found correct, Madam. In the registry, we checked.
Page को मिटा दिए, मिटा के change किए.
Madam, it seems, Madam,
Pagination are still incorrect.
they
Why didn't they, you should,
यहाँ से
I've heard you explain, you should do the pagination, correct proper pagination, because last order was there only.
no, Madam, we checked
It
with
was
the
an order, huh?
yes, Madam.
But you have not done it. Because your affidavit in reply, there is no such page like page number 68 is not available here.
मिटा के रखा.
Madam, they removed us. Madam, they have
removed
renumbered it. It's a page, Madam. 14, Madam.
How can you say now 14?
Yeah.
It will be not 14 to cannot say now. It will again create problem, you know. Because 14 pages is already there. Suppose I mean,
But earlier,
the
Madam,
order, suppose for 3 days or 1 week later also, then again it will create problem for me also.
it was
Because 14 page number is already there. We have annexed also there 14 page number. So again, it will be again a problem. The proper order was there, in fact, why?
Madam, we can confirm with the registry, Madam, say this for all right, Madam. That's why.
Now I have shown you, I
Yes.
don't know, but that was the issue.
Yes.
The last occasion also, that's what the pagination, regarding the pagination,
Yes.
the order was also passed.
I'll correct it, Madam. And this confusion, Madam,
Because otherwise it
it
create
will be
again create
difficult.
problem.
Yes, Madam.
Because suppose here is a 1 page annexure page, suppose 25 is an
Yes,
annexure.
Madam.
These are the annexures also here. So same annexures will be
Yes, ma'am.
repeated again.
Yes.
That
I'll-
will create a problem for us
I'll
also.
correct
Writing the order. Otherwise, I have heard you at length,
Yes.
na, but what to do? I hope heard Mr. Peter for the London Council for the petitioner. Also heard Mr. S. Tapin, the learned senior government advocate. For the year, respondent number?
1 and 3, Lordship.
1 and 3, and Mr. R. Sekia, the learned counsel for the respondent number 2. After hearing at a length, after hearing the matter at a length, it again revealed that there is no proper pagination of the proper pagination, especially in the affidavit in reply. However, it is submitted by Mr. Tofo that the pagination was rectified, but it seems that it has not been done in that context, and accordingly, the petitioner is hereby asked to amend the pagination and to list the matter again. It was a fixed matter, so do you what to say?
Next week, my lord.
Do you want to next week any fixed matter? Fixed date do you want? Do you want any fixed day here?
My lord, after 2
Fixed
weeks,
date?
my lord, it will be
After?
2 weeks, my lord.
No issue.
After 2 weeks?
Yes, my lord.
List the matter accordingly after 2 weeks.
Oh, nice.
I have recorded your submission.
Yes, my
also.
lord. I'm sorry, my lord. Much obliged.
Because what will create again, it will create problem.
Yes, yes, my lord.
While
Just-
at the time of passing the order.
The communication, my lord, I
Yes.
communicate properly also.
So yes, that will be all problem. And why they raised it says that it is a correct pagination because now yeah, I have shown you that
Yes.
that is the thing. The paginations are not correct.
I confirmed yesterday, my lord. They said it's correct. my lord.
Yes, one note is also here. I have seen they rectified this note is there only.
Obliged.
Item number 10.
Then একটা কথা করো। Tell her that I'll take a break at 2, at 2:12. At 12. Holiday material need.
कौन करेगा item
Cycle.
रानी है
You're going to argue the matter at this admission, then I'll just take a break for just for 5 minutes.
5 minutes, my lord.
It is an admission column.
My lord. Yes.
Mr. Das, you are having which matter, in fact?
Matter, my lord. I think it's not hearing, but is a contempt matter, item number
33.
Item number?
33. If your lordship before hearing, because this is your lordship will not hear this matter, is only for, there is certain things to be said because deputy commissioners complied the court's order.
Already complied?
They are complied, but NSPC is not complying the court's order. They are, so 2 minutes it will take, my lord, if it's not inconvenient.
Whatever, because you are sitting there, I just
Oh, no,
showing you,
thank
that's
you.
why I'm saying.
If it is not
Because up to 1 will, this bench will
That's why
be
if your
up to
lordship
1
wants-
because 2 another.
No, your
bench
lordship will
is there.
just comes and then will 2 minutes I will.
Okay then, after hearing, I'll pass we'll hear the matter.
Yes, just.
After 5 minutes, I'll write.
Yes,
Okay then. Okay. There are some matters, but what happened that one matter I have fixed for the DV matter. Tomorrow is not
Okay.
possible, so today at 2 p.m. I have
Friday
fixed
is
it.
not
at the time.
possible because your lordship.
Friday is not possible.
Yes, I.
That's what my question. Oh, আছে নেকি? যে টানো, টানো। Item
33.
item 33 निकालो।
Item number 33.
Yes. My lord, it's a contempt.
Huh.
It's a
Yes.
contempt matter. I'll not trouble with some hearing of this matter, not possible.
Huh.
My lord, there is an order. Well, I'll just tell, this is a land acquisition matter.
Okay.
It was our land. Then an award was passed by the government. They want the NSPC is a requiring agency. They want this land because for putting a power project. Accordingly, the government acquired this land. In 2018, award was passed in our favor. Now this award, they were not complying, the NSPC were not complying the orders, court's order. Then thereafter, my lord, we came to the court in 2018 by virtue of filing a writ petition 230 of 2018. We said that the award should be implemented. That amount was about 42 crores. Now, in fact, the NSPC has filed a writ petition before this Honorable Court, 242 of 2018. They said that the award should be set aside. Award should be set aside. So there were two writ petitions. It was heard by this Honorable Court. And ultimately, both the parties, myself and Mr. Tiwari was there. We agreed. A conscious decision was taken and we agreed that this cannot be under an RR Policy Act where net present value. Mr. Tiwari said that it is under the LARA Act. So we should be entitled to, it should be calculated afresh. Accordingly, a judgment was passed by this court at page 51, kindly see, my lord. The operative portion at page 51. Page 51 is a judgment which is passed on 10th of February 2025. Please see at page 51. Page 51, para 23.
Yes.
Since Mr. Tiwari, learned senior counsel for the petitioner, NSPC in writ petition 240, their writ petition, and respond number 1, 4, and 5 in writ petition 230 is our writ petition, is agreeable to pay compensation to the respond number 3 to 11 in WPC 242 and petition number 230, whatever they are entitled under this right to fair compensation, so and so 2013. Mr. Das, learned senior petitioner in 230, and so and so agreeable to accept the compensation, whatever they are entitled under the said act. This court is inclined to dispose of both the writ petition following manner. So these were the observation which was made. Kindly see the first, my lord. The respond number 2 and respond number 3 shall constitute a board to reassess the compensation which the petitioner in WPC are entitled to for acquiring the land at so and so, which has been done in the instant case. Board shall be considered adequate representation of so and so. Now C is the board shall assess the compensation each of the component as specified in the first schedule of so and after further taking into account the provision of section 29 which provides for determination of value of thing attached. D, the respond number so and so about compliance of all the provision assessing the compensation by board shall pass the award incorporating therein 12% interest on the market value of land as provided in section 30 so and so. E, the efforts shall be carried out. Now kindly see within a period of 3 months from date of receipt of the certified order. To facilitate a reconstitution.
Basically the reassessment of the compensation.
Yes. Now, my lord, 3 months, the order was passed on 10 to 2025, this order. 10th of February 2025. Now, the deputy commissioner could not complete this within 3 months, so they filed an IA before this court. 2 IAs were filed for extension of the time. We file a contempt. This is a contempt which is before this court. When a contempt was filed, they were not complying with the contempts, the order passed by the court. They came up with an application IA for extension of the order which was filed. Court granted. Twice the court granted, and ultimately they have complied with the court's order. Today they have complied with the court's order. If your lordship kindly see, the problem is not the deputy commissioner. The problem is the requiring agency is the NSPC. I'll show, my lord. Kindly see at page 181, 179. See 179, my lord. The government has complied. There is absolutely no problem from the government side. Additional affidavit, page 179, my lord. Lordship, 179.
Yes.
See, 179 is the order which they have asked for some time to be extended by the court. And see at page 180, my lord, paragraph 5. However, Consider the submission of learned counsel parties and consider that certain process has to be completed. Assessment comment is agreed by learned counsel. I am inclined to extend further 2 months time for compliance with judgment order dated so and so. 2 months is extended. Now after that, my lord, on next page, if your lordship said 181, kindly see this is a government submission of the award. 16th of July 2025, they say this for government approval, they have submitted. Deputy Commissioner has sent this land to the land management. Kindly see, my lord, at page 181. Deputy Commissioner sent it to the Secretary Land Management. Now, they calculated and they found some 48 crores has to be paid. Now, my lord, there was compliance because the NSPC, with the constitution of the board, they were also present. It's not that they were the next party. Now, at page, kindly see, at 187, government approval, kindly see at page 187. The government's approval draft award, so and so the approval of the government. At page 187, 28th of July 2025. Now, my lord, I'll just show one document which is most important, my lord, which we have not annexed. We found later on.
Appearing today, NHPC.
That's the whole problem. NSPC is not appearing in this court. Now, if your lordship kindly see, I'll cut short, my lord. Or cut short. Kindly see at page 202. My lord, your lordship, I am cutting short my argument. See page 202. Page 202. Kindly see, my lord. This is a certified as speed post letter addressed to Gaurav Kumar. He is a general manager, NSPC, has been delivered to the addressee on 17/9/2025 as per office record and status available on the website of Department of Post India. Acknowledgement card of the article was returned to the sender on the same date. Lordship, find it? This is contender number 1. Now please turn to page 203. Contempt number 5. This is to certify speed post letter addressed to so and so. He is the ED. The executive director has been delivered to the addressee on 17/9 as per office record and status available website. This acknowledgement card of the article was returned to sender on the same day. So all, my lord, the problem is that they are not eager to deposit the amount. Now kindly see, please see. Hold on. My lord, kindly see. This is the letter. Kindly see this letter which I have given, my lord. Kindly see 29th of July 2025. Kindly see. This is what compliance of judgment. Deputy Commissioner write to the executive director, where my lord, I said that he receives. It doesn't come to the court. Kindly see, my lord. Your kindly invited the following judgment. 1, 2, 3. Kindly see subpara. In pursuance of direction to the Honorable High Court, an extension accorded. The report of the board with the award as finalist for amount of so and so was submitted to government for consideration by so and so. Government approval has been accorded to the fresh award dated. You are requested to deposit the award amount of so and so a joint account of the earliest so that the exercise is completed by 10th of August 2025 in line with the judgment order and extension given by Honorable High Court and to be communicated to Honorable High Court regarding compliance of the same. Now, after this, my lord, at page 187A, kindly see the petition, my lord, 187A, they write to us, to Deputy Commissioner, at page 187A. Now, kindly see the last line, my lord. After 4th point, in view of the above, kindly see, it is submitted that upon receipt of final revised award and further direction from the Honorable High Court in the matter, NSP shall take immediate step for deposit of as desired by your office, letter dated. We assure you of our continued commitment in complying with all legal direction and statutory requirement. Now, see point number 4. Honorable High Court has not directed deposit any compensation at this stage. Deposit of the compensation amount by so and so subsequent deposit may be considered only after passing of any order by High Court in the matter. Where is the question of High Court again giving a direction to them? And in fact, Deputy Commissioner at page 188 had written back to the NSPC. Kindly see NSPC. See, my lord, NSPC, 1st of August 2025. This is a letter written by DC to the Executive Director. Contempt number 5. If your lordship turn to 190, see 190, page 190E. See 190E, my lord. See E, my lord. The entire process of preparation of award to deposit of compensation is implied in the judgment order dated 10th of February 2025. There is no direction that the award is to be submitted to the Honorable Court for passing of any order by the Honorable High Court. Deputy Commissioner said, where is the question? Again, the High Court will pass. Now, what I pray today, my lord, there is an order. I have seen that there is an office note where on 29, so 25/9/2025, some submission was made. The Deputy Commissioner, some new incumbent has come, and that's why we have to make a party. I think it's not necessary at this stage. See, my lord, 25/9/2025, because their part they have complied. We are not really agreed by Deputy Commissioner. We are really agreed by NSPC. Today, they are avoiding in spite of the service which has been completed. They doesn't come to the court. My lord, we see what torture they have done to all these owners. From 2018 and today in 2025, they said in the open court that you are not, but you are entitled to come under the Lara Act. We agreed. Okay, fine. The board constituted, they were there. After they agreed that this is the amount. Today they are not coming to the court, even in spite of the, my lord has seen the report. So what I pray, my lord, that we will take a dusty service on them, because it is permissible under the contempt. We have seen order of the Supreme Court that in contempt also dusty service is permissible. Kindly see this. Normally, he said that how a dusty service. They appeared, my lord. Your lordship has seen both the reports, even in spite. Now there are judgment of this Supreme Court, I will say later on, not trouble. Even in contempt, in 2024, there is a judgment, latest judgment of the Supreme Court, said they have to comply, and interim order can be passed by the High Court also. Contempt, normally we say that no, let him, it is only a violation of the court's order, but ancillary order can be also be passed. This is order of the Supreme Court. So dusty service can be taken, my lord, in a contempt proceeding also. So my prayer before is this, my lord, we'll take a dusty service, my lord. And compliance report will file it on Monday itself.
NSPC generally one contender.
1 and 5.
1 and 5.
5. And
1, 5.
yes, 1, 5. And another is there, we will not take, let 1 and 5 is rowing, my lord, is very near. 1.
Land management has already appeared.
They appeared. There is no problem, my lord. 1 is the general manager, will take a dusty service. And number 4, sorry, 5, number 5. Let these 2 persons come and at least they can say before the court. Let them come, my lord. They should, my lord. This type, my lord, we are not ignoring the court's order, not at all interested. This is what, my lord. And we are suffering, all landowners.
Shown this service of notice on them through, that was in the earlier stage or not before the court?
No, it was, my lord, but this service, man.
No, page number in.
For 203.
203, yes?
Yes.
Yes.
We have taken steps. Page 20.
As per this 203.
202, 203, we have taken step. AD has not come. Tracking record, ordinary post.
But this shows that.
Yes, they have received.
They have received.
Received. Even after receipt also, they are not before the court. This is the deputy commissioners complied with the court's order. This is, my lord, that's why, my lord, I have to come personally, my lord. And exchange.
You obtain those, the certificate from the postmaster.
Yes.
Yes, Mr. Tapin, it is here now this, as Mr. Das is submitting that, though you have submitted the new incumbent is there, but your part has already been complied with.
Only what I pray that justice service will take and let this matter come on Monday, my lord. These are too much, my lord. They are suffering like anything from 2018.
May not serve your purpose. Monday.
No, what we will do it?
Done, Monday.
No, yes, rowing is, I asked my client. He said that we'll go, we'll serve the copy because tomorrow is Friday. So if your lordship is kind enough that to sign it, we'll take it. And he will serve it on Friday. And Monday in the morning we'll serve, we will file it. Is only affidavit has to be filed. We'll give it to the court, my lord. Dusty has to be completed. Even in spite, they know it very well, my lord. They have, it has been served to them.
Heard Mr. D. Dust, the learned senior advocate, assisted by Mr. Idas, the learned counsel for the petitioner. And also heard Mr. S. Tapin, the learned counsel, appearing. You are appearing for state response number one? What? One?
Three.
No, sorry, two? Not two.
No, yes, 2 and 3.
2 and 3.
2 and 3.
2 and 3.
Your lordship will only indicate they have complied and they are just waiting for the amount.
Mr. Das, the learned senior advocate, that Deputy Commissioner has already complied with the court's order. However, the contempt petitioner number 1 and the contempt petitioner number 5, who were he is the director of?
One is executive director, one is the general manager.
General manager, NHPC, and the executive director, NHPC, has not appeared before the court, but through the additional affidavit, it is submitted by Mr. Das that notice has already been received. Notices have already been received by the respondents, oblique the contempt petitioner number 1 and 5, and to that extent.
1 and 5, container 1 and
1 and 5, and to that extent, they have already also submitted the certificate issued by the the postmaster general. However, it is submitted by Mr. Das that he may be permitted to issue notice to the contempt petitioner or respondent of the contempt petitioner number 1 and 5 through dusty mode, and it is submitted that as per the order of the Honorable Supreme Court, past in contempt petition bracket of civil 418-2420/2025. The dusty service is also permissible in a case of contempt petition. Considering the submission made by learned counsel for the petitioner, the petitioner is hereby asked to take steps to dusty mode, and the affidavit shall be furnished to that regard. Do I want to submit Monday?
Yeah, Monday. Let it come on Monday, this matter.
Please do matter accordingly on Monday. Monday means, you want right? Monday is 10th.
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 Yeah.
Okay, we're listing it on 10th.
10th, my lord. 10th.
Further,
pending will not be bar. NSPC, why are you doing the pending will not be a bar to deposit the amount. Even today, also your lordship can pass an interim order also in a contempt. Because like your lordship knows, a civil case, when a decree is passed, execution proceeding is there. But a contempt, there is no execution proceeding. That is why Supreme Court has come out a new judgment saying that you cannot enjoy the fruits of a decree holder like in a civil court. So now in the judgment of the Supreme Court in 2024 made it very clear, ancillary order can be passed by the High Court. Otherwise, what they will do, tomorrow they will come to the court, not any space, any other will come, no, we will not pay, let us go into jail. Then ultimately, it is a big zero of hearing the matter, passing an order. That is why this order has been passed by the Supreme Court, my lord. It's a reported judgment of the Supreme Court.
Mr. Tapin, that part also we can add that regarding the new incumbent, implement of a new incumbent.
Lordship,
If has
that-
already,
that
is,
part-
you don't want to submit
Yes,
anything, yes.
so far respondent number 3 is concerned. She has been already transferred out. Now new incumbent has come. And there's no application from the Lordship petition
My lord,
to implement that new incumbent, Lordship.
if a
Now,
Therefore,
now, as per,
it was already observed in earlier order.
it is already observed. That's why I'm asking.
Yes.
Suppose number 3 has already transferred, no?
Yes.
She got transferred. So as per the petitioner side, your part, I mean, part from the DC is already complied with the
Lost.
order of the court.
Lost.
So in that, if you go by that context or
Lordship, in future, let's say,
No, you're
in
right.
future,
Future.
if the amount is
Something,
deposited,
yes.
I have to disburse again, Lordship.
No, no,
Deputy Commissioner has to disburse again.
yes.
So I think
No, we'll,
it will be proper if his new incumbent is implemented.
no, we what we'll
It's
do.
up to the petitioner.
No,
I have no.
during the course of some few days, like Monday, Tuesday, we can file an application impleading as a party. There is absolutely no problem. He's right. But today, as on date, we are more concerned of depositing the amount before Deputy Commissioner's account. That is why we will make a, my lord, he's right. In future.
Yes, in
So maybe on Monday or Tuesday, we may file an application before the.
it is further it is asked, but it is further considering the submission made by Mr. Das Dilan, senior advocate. Then the interlocutory application may be filed for implement of the new incumbent in respondent number as a respondent 3 of the contempt petition. Sorry, contempt.
We will file an application. My lord, I not troubling today, but I think that on the next time, definitely CMD has to come to Arunachal. Let NSPC CMD come from Delhi.
Here also,
He doesn't come. That's the whole problem.
NSPC was represented by the council here.
Yes, Mr. Saxena is there, Mr. Tiwari.
Tiwari is also there.
Yes. I can sub a copy to Mr. Saxena also. That's end of the matter. Why not? My lord, we have seen when we're sitting in court now, I said, you are appearing, why don't you accept? Sometimes we said that we don't have an authority.
That is the procedure.
Yes.
Yeah, that can be.
Yeah.
And as you have submitted that in the earlier occasion, Mr. Tiwari had, and this was agreed by both the
But
parties. That's why.
technically, Lordship, here their party is in person, Lordship. So therefore, they are not in position to appear unless they are authorized. They can.
No, why they are not appearing? Because my lord,
One technical, Lordship.
my lord, technically is.
Otherwise, they can assist.
No. There is a contempt. That's why they are not coming up. Maybe in a contempt. But very well, my lord, they all know that this has been served, but they are not coming to the court. It's a fact. Fact, my lord. They are not coming to the court.
Okay, then. Easy.
Deeply obliged, man.
Item number 10.
Just he wants.
My lord,
yes,
one
one matter is there in item number 34.
34.
That the small matter that the order has to be passed. Anyway, I'll pass the order.
My lord,
Is that item number 10? You will take.
My lord, not much time, my lord, because here it's very simple.
Because of the I have a time only up to 1.
My lord.
He knows, Mr. Taro knows that we had that fixed the matter at 2.
Yes, ma'am.
At 2. So
Then,
within half an hour, if it can be completed by both the sides, then I'm interested to hear because part third cannot be there.
Yes, ma'am. Half an hour may not, I may take alone because there's some questions of law that I've framed, my lord. And this is a section 64 matter, my lord, Allah Act, my lord, where a dispute has come, whether the deputy commissioner was right in directing me to go to a civil court instead of referring me to the authority, my lord. And then
Why it has been done, I have seen the record.
Yes, my lord. So
generally, it has to be referred. It should be.
it has to be referred, and then and thereafter, my lord, we were proceeding in a wrong forum. Then finally it says, no, I cannot entertain your petition. Then I went back to the authority with an application 64, and then the authority is saying, no, you go back to the DC. So I've been pushed around. That's finally where I land up before my lord. So this will take little time, my lord.
Little time.
Yes.
That's why I'm asking, because up to 1 may not be possible. At 34, I'll pass the order. It is simple order. Yes, yes. It is already infructuous order. Yes. So yes, Mr. Nabam, then it will be fixed another date because due to time constraint.
Yes,
Otherwise,
My lord, I was supposed to address in that line, but my friend started. My lord, since this is a fixed matter, so even I thought, my lord, I will not adjourn, my lord. Since there is a paucity of time, my lord. Any date in next week.
That is the on my part. I cannot say
My lord.
that if that matter starts at 2.
Yes.
I don't know. It may take again time to up to 4 and all. Otherwise, if it is by end up by 3:30 or 3, then in that case also I can take one chance. But
Any date, madam, next week, any date.
week, any date.
Well,
May I pray because I come from out of station, but if
Okay,
it's 12th, my lord, 12th of November, my lord. If
12th
it's
November.
12th of November. That's
No, that is 12 number is Friday.
No,
So-
no, not Friday.
No, it's not a
Wednesday.
Friday.
November.
It's a Tuesday.
No,
It's Wednesday. It's a Wednesday.
Wednesday. Generally,
Wednesday.
we keep Wednesday as a this division bench also.
Oh, my lord.
So, oh, sorry, division
DB.
bench, but DB is there.
Mhm.
So can it be on the, my lord, either 11 or
Apart from 12th, what will be your convenient date? As per your
Or
convenient
10th, my lord, there's some other matter on 10th. I'm coming on 10th.
Why not
10th
13?
also.
10th. Is it
12, I have some problem. 13?
That's the reason. That's the reason.
All right. That's the you're coming to Assam. But you said that 12, I have some problem.
No, no. So I'm going back to 10th, so if it's possible.
10th.
Yeah.
10th. All right, we can try 10, no issue, my lord. 10th.
On 10th? you can
10th,
try.
my lord. My lord, 10th of November.
So your return here for come from?
I'm come from Shillong, my lord.
Oh,
Meghalaya.
Shillong.
My lord.
Okay, okay. So you're going back today?
Tomorrow.
Coming again or tomorrow?
Tomorrow.
Coming again on Monday?
My lord. Yes.
If it is okay for you, then we can fix it on Monday.
My lord. Monday will be fine, my lord.
Monday, Lordship, I might have some difficulties.
Then let us take on December, my lord. And
Saturday and Sunday, Lordship, I'll be out of school.
Now, Mr. Navam is saying that why don't you take on 13th? Can it be? Because 13th will be a single bench also.
13th, yeah.
My lord, 13, my lord, if I can join virtual, it's fine, my lord. No problem, my lord, for me. If I can join virtual.
Now see,
Virtual basically is very difficult, my lord.
Personally, I don't prefer virtual.
My lord, otherwise, on then if December 9th, my lord, if it's not inconvenience to my lord.
December 9th. Okay? All right, madam, December 9th, no issue.
And then December 9th already? Okay. So you are Mr.?
Yobin, P. Yobin, my lord. P. Dot Y-O-B-I-N.
You're for the petitioner, no?
My lord.
Yes. So and so. P. Wabin, the learned counsel for the petitioner, and also heard. Mr. N.H. Navam, the learned.
My lord, R.H. Navam, not N.H. Navam, R.H. Navam, my lord.
Oh, sorry, R.H. Navam, the learned additional AG, appearing on for the respondent number?
1 and 3, my lord.
1 and 2. And you are Mr. Jini, na? You are appearing for?
4 and 5.
4 and 5. And also heard Mr. J. Jini, the learned counsel, appearing for the respondent number 4 and 5. The matter was fixed for admission hearing today, but due to paucity of time, it could not be taken up. Let the matter be accordingly listed on 9th of December. Yes.
9th of December.
9th of December 2025. As agreed upon Likido, as agreed by both the parties, let the matter be listed on 9/12. Okay, we're listing it 9/12. Hopefully, it can be heard by had some person. Otherwise, no issue was there.
My lord.
Because what had happened yesterday, but that day we fixed it at 2 these division bench matter.
My lord.
And constitution of that bench is a bit problematic for us. For Bishop, my brother Panjal Das and me, we are here. So again, for constitution of that division bench, it's quite problematic. So I thought that it's better to complete it. That's all.
Item number
34 and also.
Item number 34.
Bring 34. 34 first. 34, yes, 34 is there. Is there any 34? Yes, whether this applicant is, I mean, the petitioner is here today? No.
You was seen.
I have seen this matter.
Yes, I have.
That bail application has already been disposed of.
Disposed of, rejected.
No, why? Yes.
Yes, because
but he is absent today.
No, he was seen earlier today.
He is present.
Yes.
Then it can be taken up after that. For time being, we keep it.
No, he,
The petitioner counsel is present.
yes, I informed him and he told me that it's become already in practice. He also admitted the fact because main application, because this is for, I is for implement of the complainant as a
Yes.
party in bail matter and bail matter, main bail application
Is
was already,
not in existence.
Yes.
Yes. Huh.
so it become in practice only.
So what can we do? Can we pass the order in his absence or what to do? That's what I'm saying.
Yes, I already informed him otherwise. Today,
It's okay.
today, it's,
Okay, then none appears on call for the, in I-34, none appears on call for the petitioner. I heard Mr. G. Tadu, the learned additional PP appearing on behalf of state respondent. This is an application filed by the petitioner praying for impleading him as a party in the bail application number 88/2025, who is the son of the deceased victim. But from the record, it reveals, and from the record as well as from the submission made by Mr. Tadu, the learned additional PP, it is seen that that said bail application number 88/2025 has already been disposed of. And hence, at this stage, the question of impleading the present petitioner as a party respondent to the said application does not arise. Accordingly, it is seen that the present application is not maintainable at present. However, the petitioner may approach the court with another bail application, another may approach the court with another application if so advised. With the above observation, the present petition stands disposed. Okay.
it was listed because of miscommunication between Deputy Registrar of our High Court and Joint Registrar of our, for listing the matter along with the main application. It was not listed on that point of time when main bail petition was disposed of.
It was not before the court.
No, it was not listed before the main application, this IA. And it was because of miscommunication between our joint, the Deputy Registrar and Joint Registrar. It was communication.
No, the order was passed on which date? The bail order was?
May 8 September 2025.
8?
September 2025.
8 September 2025. And
bail
this
was
application was filed on?
This application was also filed on 7th September 2025, but it was not listed on the date main bail application was fixed. It was not along with.
Madam, this become in practice. Actually, when the bail, the matter was taken up, my lord, the applicant counsel present, they were duly represented and their presence were recorded in the bail application. And they were heard. This became in practice.
Submission was also recorded.
Yes, this was, it will become in practice. Most probably because of the communication gap, this has leased up. Actually, this has been disposed of, this entire case.
Order लिखो, more so. No, this petition, you're going to represent this petitioner here?
My lord,
Your name can be recorded
in
now?
the bail application, I was the applicant, my lord.
Yes.
I was applicant. This I was present, and since the complainant, the applicant in the IA, he was heard and allowed to make.
Yes, he was allowed to make submission.
So that's why this IA was not required at all, madam. This was.
No, can I
formal.
record your name as a petitioner? No.
No, my lord.
You are not.
I'm not.
Okay. Further, from the submission made by Mr. Tadu, it also appears that, and from the record, it also reveals that the present petitioner was accordingly heard at the time of disposing the earlier bail application number BA 88 so and so. In view of this, the present interlocutory application has already become infructuous and accordingly disposed. Okay.
Item number 11.
ये तो की इस क्या है ये?
Please.
क्या है इसमें? Item 11.
Item 11, my lord. My lord, this is an eviction matter, my lord. Where initially, in fact, I had filed a WPC 433 of 24, my lord. Because the deputy commissioner, when I preferred an appeal against the order of the estate officer, he refused to take it up and remanded the matter back to the estate officer. So against that, I had come to this honorable court, and at that time, initially some interim order was granted in that WPC 433, man. And while granting that interim order, liberty was given to the deputy commissioner to dispose the appeal, man. Now the deputy commissioner gave me an information directing me to appear on 7th of October this 2024. And on that day, I appeared before the deputy commissioner, but no hearing took place. It was just the deputy commissioner and the petitioner. They discussed, and the deputy commissioner said, okay, because the original appeal petition, it was originally returned. So I was asked.
The original appeal application is where it is, before the DC or
before the
still now
DC.
before DC?
DC, now original as such I have with me now. And since there was no appeal petition as such, also no proper hearing took place. And I was given
What
some.
was the order before by the DC? What order was passed by the DC in regards to that appeal?
Appeal initially, since he did not take up the appeal, so I had come to before this honorable court, and in the in WPC 433 of 24. Now in the WPC 433/24, liberty was given to the deputy commissioner to take up the matter and dispose it accordingly. But when the deputy commissioner fixed the matter on 7th of 7/10/2024, no hearing took place, and in fact I was given some time to file a appeal, proper appeal. Now I filed an appeal on 16/10/2024 because the deputy commissioner, of course, he is busy. He was busy in his various administrative functions also. No further hearing took place, and on 24/10/2024, order of 7/10, backdated order, it was given to me, and that's why I was this present writ petition has been filed. Now, if
No. Question is that in WPC 433/2024, the DC, the liberty was granted to the DC that you can dispose of or you can hear the appeal. Accordingly, date was fixed on 7/10, but there was no hearing at all.
No, ma'am.
And then again, you preferred appeal. One appeal on 16/10/2024 before the DC.
Yes, my lord, I filed a
Now,
fresh,
is the
fresh application.
status of that appeal?
That appeal, it has not been taken up. In fact, on the backdated order I received on 22nd, saying that the impugned, that order that has been impugned in this writ petition, my lord, that was passed on 7/10/2024.
But as per you, there was no such order, no hearing.
No hearing took place. And if your lordship would come to the order observation of this honorable court, my lord, of 12/2/2025. my lord.
Yes, 12/2.
I will just read this order, ma'am. Heard Mr. So-and-so, learned counsel for the writ petition, also heard Mr. So-and-so, so-and-so. In this writ petition, the order dated 7/10/2024 passed by the Deputy Commissioner, Upper Subansiri District, Daporizio, has been put under challenge, primarily on the ground that the petitioner was not given proper opportunity of being heard before disposing of the appeal filed against the impugned notice dated so-and-so, issued by the Additional Deputy Commissioner, Taking note of the grievance of the petitioner, this court had passed order dated 5/11/2024, directing both the parties to maintain a status quo over the property in question. In fact, in this writ petition, my lord, your lordship had called for order, my lord, called for the records also, my lord. Now, today, when the matter is called of Ms. So-and-so, learned government network, appearing for the respondents, has produced the departmental records to submit that the appeal was disposed of after giving personal hearing to the petitioner. However, there is nothing in the record to substantiate such stand of the learned government advocate. AP reader, from the record, it appears that no proceeding of hearing of the appeal was at all recorded by the learned Deputy Commissioner, Upper Subansiri District. So this court has already come to a finding also that after the perusal of the records. So may pray, my lord, instead of keeping this pending, my lord, let that order, my lord, that impugn order be set aside. Let it be remanded back to the deputy commissioner. Let a proper hearing take place, my lord. Because this court has otherwise taken judicial note after perusal of the report that there's nothing on record to show that hearing took place, ma'am.
Yes, there's an observation made in this order of 2025 that though it has been, it was told that the hearing taken place on 7/10/2025, but in fact there is no such hearing, or you could not substantiate that your plea by producing any document and all. That was the observation. So
That has been recorded, but then Lordship, on that day also my submission was that Lordship, on 1st October 2024, Lordship, order was given that the hearing will be taken up, Lordship, on 7th October. This order was given to the
here
this
also your
petitioner also.
submission is already recorded, as has been herein above the recorded producer so and so. Indicate hearing was taken by serving notice on 1/10/2024.
Those
That
are
was
those,
again there is an observation. However, there is nothing in the record even remotely to show that the petitioner was given at all a proper opportunity of being heard in the matter.
Lordship, that has been, Lordship, I understand, but then.
I mean, what I'm saying that after appraisal of the record, that observation has already been made by this court. But I don't know, since the respondent already.
But then, Lordship, my only apprehension is that when this matter is, Lordship, this order is set aside, the petitioner may continue to construct the building, which
No,
is
my
the
lord, no.
building, Lordship.
my lord, I've already given undertaking. Today also I give an undertaking, my lord. I have not gone further with the construction, my lord. Today also I give that undertaking also. I will not go further with the construction, my lord. And otherwise there is an interim order in favor of me, my lord. Keeping this pending, my lord, it doesn't serve the purpose of the government also, my lord.
No, but the question is this, apart from this observation, do you want to submit anything? Because question is that though this observation was made on or by the order dated 12/2.
Yes. Lordship, what we have said is this order has been, the appeal has been taken up after receiving the honorable court's order in compliance of the honorable
WPC.
court order in WPC
433.
Yes, Lordship. And then accordingly, in my, it is,
so in that regard, you have filed your affidavit?
yes, Lordship.
Oh.
Lordship, may peruse my affidavit, Lordship.
Achha.
Page 29, Lordship.
Page
29. My affidavit, Lordship. Oh, no.
Starts at page 38.
I'm sorry, Lordship.
It's not 29, I think.
Page, Lordship.
Page 30, what is this? Before the deputy commissioner?
This is, I was,
This is, my lord, my petition. my
Your
lord.
petition.
This is the writ petition.
Lordship, in writ petition 29, Lordship will see. Lordship, this order was given, Lordship, conveying the petitioner that on 7th, they will be heard, Lordship. Page 29, Lordship, of the writ petition.
My lord, I am not disputing those facts. I am not saying that I did not receive the order of the first. I am not saying that I did not appear on 7th, my lord. My only thing is that no hearing took place and which has been recorded by this Honorable Court, my lord, after perusal of the records. I'm not denying I did not appear on 7. I appeared, but hearing did not take place.
Lordship, he couldn't produce anything, Lordship, in the this one also. Here we have said in the order.
So where is
itself,
your,
it
where is your
reflects-
affidavit? Affidavit?
Affidavit, Lordship, my affidavit starts from. It
This
should be
is
there,
affidavit,
Lordship.
Your affidavit starts from 30.
Page 38. Page 30.
Then can you tell us why those observation was there that there is nothing in the record?
Lordship, that's
So show that there was any hearing or
Lordship,
there was any.
I have the is a record still. Lordship may peruse. They here they had the appeal petition copy with them. Though it's in Lordship. The in
Appeal petition
original.
is filed by them, it is admitted,
Yes.
isn't it?
Yes, Lordship.
They
This is
have
the
already
first
filed.
appeal is 17/9/24. According to the Honorable Court's direction, Lordship, since the Lordship in the 334 liberty is already been given to the Deputy Commissioner.
Yes, yes,
to
that is
take up the appeal.
liberty is
Lordship.
given.
Accordingly, Lordship, this order was given notifying him that the matter will be taken up on, hearing will be taken
But
up on 7th
notification was on
October.
110.
Yes, on 110.
Ah.
And accordingly on 7, he came, Lordship, the petitioner came.
No, it is admitted, he came.
And then
As
Lordship,
per him, there was no hearing at all. And the order was passed backdated.
Lordship,
That is
no,
it.
that cannot be. He is also saying he came, Lordship. What hearing can be done, Lordship? He have demolished the quarter, type 3 quarter, and on there he is building his own construction. He's building own construction, and then what he's saying is, Lordship, in the Lordship can see in the this one impugn order itself, Lordship. What he's saying is that he let him build that construction fully, and from there he will give a type 3 home to the government so that they can, Lordship. That's
How
what
it
he's
can be
saying.
possible? Ah.
He said that, Lordship, we have in the order itself is
Okay, then some hearing is required and for on your submission, obviously 212 or 212, whatever, was the order, there was some observation, but therefore they have come with a affidavit with some documents as well as the recording of it there.
Yes.
So
There is
it will
otherwise,
take
there is
some time.
nothing on the record also, in the affidavit also. Only they have annexed the order of the impugn order, which I've already annexed, my lord.
Lordship, if the hearing
As per you, that
Again
impugn order was a
also.
backdated order.
Backdated order, my lord, because, my lord, it's not my saying. And against this observation of this honorable court, the state has done nothing, my lord. This is order stains the observation of this finding. And in fact, the honorable court says the hearing, it should be in letter and spirit, my lord. You cannot just do things like that, man. It has to be done properly. Otherwise, my lord, fix it for.
This today too will be problematic for me also to peruse this record and all due to shortage of time. Otherwise,
Man.
due to positive time. Folsom,
Otherwise, Lordship, the petitioner didn't have any right, Lordship.
My lord, I'm not claiming about any right. I'm only asking about the procedure, man.
item number?
Item number 11.
Oh, 11, sorry. But you are constructing your.
I'm not constructing, my lord. This is stay. I had also given an undertaking. There's nothing going on, my lord, as of now, man.
Had Mr. D. Soki, the learned counsel for the petitioners, and also had MS Chieti, the learned senior government advocate for the state respondent. The state respondent had already filed their affidavit in opposition. Let the matter be listed. Do you want any fixed date here or after 1 week will do?
Let it be listed for hearing after 2 or 3 weeks, my lord.
Let it be after 2 weeks then.
My lord.
The matter be listed after 2 weeks.
For hearing.
In a hearing column. And further, the interim order passed earlier shall continue till next date of listing. So you were directed to maintain status quo over the land.
Yes, status quo. Okay.
Now, how will you show that he was personally personal presence is also admitted by him, that he was present on 7/10.
It is
It's
reflected-
interesting because
It is
personal.
reflected in the order, Lordship.
Yes, yes,
The precaution.
and he is also saying that he was present, but no hearing took place. That is his only condition.
Yes, ma'am.
So now you have to prove that no, that your hearing was there, and accordingly the order was passed on 7/10, not backdated.
We have said that only in the Lordship affidavit.
Because, my
We
lord,
have said that.
the,
What more he can produce, Lordship? He said illegal, Lordship. Construction is going on. He's not an LOT.
because, my lord, the order, my lord, is heavily influenced, Deputy Commissioner and SR, it is heavily influenced by their observation that I dismantled, my lord. So those things have to come up, my lord, please. So, all right.
Item number 15, 16, and 18.
Please, my lord. My lord, item 18 is similar to the item number 5.
So item number we had already heard.
Yes,
It means it was submitted that those items, those we have already heard, like 5, 6, 7, 8, 12, 13, 14, 17, 19, 20, 21, 22, 23, 24, and 25.
Yes, my lord.
So now your matters are about 15.
Mine is only, my lord, 18.
Your one is 18.
18. But mine in beside, my lord, submission of my elder brother made in the other items. I would like to submit a small point, my lord. If this
Then
pending,
though I don't have time.
only one paragraph, my lord, just to point out this one, this paragraph 28 of our Honorable Supreme Court judgment. If the pending petitioners were not protected, then they would not have mentioned this. However, in the paragraph 28 of the judgment passed in the main lines, apex
And
court.
that is already submitted by Mr. Tofo. That is the observation.
Yes.
That is the we can appreciate the meaning of that line in that
Yes,
way.
because the concluded that acquisition is not covered, cannot be reopened. But it's observed that, however, the pending matters, this wouldn't have been added if Honorable Apex Court was not intended to protect those pending cases which before the Honorable Court or the Honorable
If the
Tribunal
word,
Court.
however, was not there.
Yes. However, would not have been added.
Yes.
Simply they have been left. All those concluded acquisition process is not covered. That would have been there. But however it's added, it means Honorable Apex Court protected us, those who have approached the authority concerned being aggrieved by non-payment of the solution. Only this point I would like to add.
Yes, that but already Mr. Tofo has already submitted. So you are on item number 18.
18, my lord.
Item number 18. Why it is in order column? Can you tell us?
Because pendency of my lord, this
No,
matter.
why it is in order column, not in admission column? That's why I am asking.
Actually, the respondent wanted to this main
They are not going to file. Most probably they have already submitted this thing.
Yes.
Verbally submitted.
Yes, my lord.
So now 18 is also with the same set.
Yes.
Oh. You do what to do one thing. Mr. Tofo is appearing all these items.
Yes.
Similar, same set of items. Now 18 is also as per him same. So you just write the name and all, the counsel for the petition.
Yeah, Lordship.
And the
In Lordship, this item number.
just a second, in all these items. And the other side, this comment is there, and Mr. R. Sake is also there. His name will be there only. And the 18 is different matter, and your one is 15.
15, Lordship. It is the same similar case of nature, which
This
is
is
hard
also
on
similar for
Lordship.
case of
All the contention
are same.
similar.
So 15 is also can be stated as a heard, and write the name of the petitioner here, counsel for the petitioner here.
Sure.
And yes, you want to submit here also, because we have heard these things.
Yes.
Mr. Ratan was there.
Yes.
So basically, they are relying on that the judgment, wherein it says that if the acquisition process is already concluded, then there are question of solution and all, it doesn't arise.
Yes.
But there, however, point is there, so they're basically pressing on that word, however. So we have to interpret these things. That is the only issue. That apart, most probably, it is an accepted fact that the acquisition process is
My lord,
concluded.
she is not there. Not in that case. She is in 16, item number 16.
Okay.
Item number 16 is a
Item
bit
is
different.
A bit different.
Ah.
Okay then.
I have filed rejoinder today.
Okay, you are not on that series, no?
No.
Okay.
She is in item
15 cases are include query 15 and 18.
18 CAB.
15 and 18.
15 and 18.
15 plus 18. Huh? 18 will be added in the same series. And then 16 different where you have filed your
rejoinder I have filed today.
Today you have filed your
Let this matter be listed for hearing, my lord.
Yes.
After
Okay.
3 weeks.
After 3 weeks. Heard Mr. S.
Koyang,
the learned counsel for the petition. Item number 16 you write, huh? And also heard MST Ete, the learned senior government advocate for the state respondent. And it is submitted by Mr. Koyang that they have already filed the affidavit, rejoinder affidavit today, and prayed to fix the matter for hearing. Full stop. Considering the submission made by learned counsel for both sides, let the matter be listed after 3 weeks in hearing column. Okay, it will be in hearing column.
Yes, ma'am.
Okay.
Obliged.
Item number 26.
Obliged.
Okay. 26 may not be possible.
Yes.
Because what had happened, I have already said that the one matter is fixed at 2, at DB matter. So it may not be possible. That is same with 26 you are appearing.
Yes, ma'am. Yes, sir.
Please record the names, and due to paucity of time, same order will be there. It may be otherwise pleadings is completed here.
Yes, madam.
Pleadings are completed.
I have filed everyone. They have to file rejoinder, madam.
You want to file rejoinder here? Do you have any instructions? You have to file rejoinder.
Yes, we will file in.
Okay, then. In that case, you are MS?
N. Hondik.
M. Handik?
N. Handik, on behalf of T. Taba.
Naam to likhi loga. So and so appearing on behalf of Mr. T. Taba, and also her, MS Yuva Ango, the learned government advocate for the respondent. However, it is submitted by MS so that they are going to file the rejoinder in this case. Full stop. Prayer allowed. List the matter. How many weeks you need? 2 weeks?
After 2 weeks.
Let the matter be listed after 2 weeks as an date to be fixed by the ministry.
Item number 27.
Lordship, in fact, this matter has become infructuous, but the review petitioners are not here. We have received all the bill has been cleared.
It has already, you have already received.
Yeah, received.
However, you are for the respondent, I think.
Yes, I'm for the respondent. The review petitioner, Food and Civil Supply Standing Council. He informed us that he'll be here tomorrow. He's not here today.
Oh.
So if time permits, if it can be listed tomorrow.
Tomorrow it may not be listed. It may be possible for us. We'll do one thing. We'll ask the registry to list the matter either by Monday, Tuesday, or Wednesday next week any day.
Lordship.
And matter may be heard through virtual mode.
Lordship.
From the principal seat, because I'll be there in the principal seat next week. So it may be heard from the principal seat. As you have submitted that you have received the entire compensation amount has already been disbursed. Na?
Yes.
Okay.
I came from Guwahati, so I can appear there and they can appear from here. So if
they can also appear from Guwahati.
Okay.
On the last occasion, I Chaudhary was appearing, I think.
AG. No, now Food and Civil Supply, they have standing council, so they are saying that you will be appearing.
Or they are going to appear.
Yeah.
Who is the here council here?
Jammu.
Acha.
Tagum Jammu. But government.
Last occasion, D. Majumdar. Oh, you're for the respondent, na?
Yes.
Yes, yes. Taplin was appearing, I don't know, anyway. He was here only, I don't know now.
But actually, Food and Civil Supply Council, he informed us that he will be here tomorrow. So otherwise, you can list it in the principal bench and we can take up through risk.
Okay then. Non-application call for the review petition. Heard MS, what's her name was?
Somila.
Sharmila. Somila, na?
Yes.
SOMILS. Somila, appearing on behalf of Mr.
SK Deori.
You are appearing for the SK Deori?
Yes.
SK
I
Deori.
think I am on record.
Yes. Yeah. No, here too, your name has not been reflected
Yes,
today.
it's not reflected in.
We'll pass the order.
Okay.
তেতিয়াহ'লে নালাগে, you don't write for you don't like, right? Heard non-application call for the review petitioner, heard MS Somila, the counsel for the respondent. And it is also submitted by MS Somila that the case has already become infructuous as the compensation amount has already been disbursed to the respondent. Full stop. However, due to absence of the review petitioner, the order could not be passed. Let the matter be accordingly listed next week. Next week it can be listed. Next week as on a date to be fixed by the registry. Through VC, I'll take the matter. Further, the registry is hereby also directed to reflect the name of MS Somila in the cause list on the next date of listing. Okay.
Item number 28.
Wait, please, Your Lordship.
28, now it is 28 is for this IA or for?
Hearing on
Madam,
IA.
there are two interlocutory applications pending. So
One
those
is
are required to be
Mr.
heard.
You have to hear the matter
My
from
lord.
the principal seat itself because
Yes,
today,
it is
due to
better, my
paucity
lord.
of time, I cannot hear the matter.
Yes.
And
Even
one
otherwise,
matter
my lord,
is-
this-
one matter is fixed at 2 p.m.
Yes. When
And
you are
that's
not.
why otherwise it could have been taken at 2 p.m. but 2 p.m. the DV matter is fixed.
Yes.
So it can be heard from the principal seat itself.
Yes.
So,
In that case, can it be fixed on 28?
Yes, ma'am.
2-8.
20.
2-0.
Yes.
2-0.
Is it Thursday, my lord? Hearing day. Give it an unletter. কোনটা এই ইস্যুর জন্য? 214 striking 214 or 248 amendment. 244 of the
Mr. Mojumdar is appearing for the respondent, na?
I am for the
Respondent.
respondent, applicant in this IA.
I. আচ্ছা। I লিখি দিব একেলগে গোটেইকেইটা লিখি দিব। And Anju was there. Do you have it? Mr. You are appealing for
Madam,
respondent
I'm
number?
assisting.
Oh,
senior
assisting
counsel.
Mr. Okay. So you are for the petition.
Yes, respondent. Election
You are
petitioner.
not for the respondent.
Is election
In the-
respondent.
my lord,
This
in the-
respond.
In the election
Petitioner
petition, they are the
respondent.
petitioner.
Petitioner.
Yes. You are Mr. Eta.
Eta.
Tata, the learned counsel for the petitioner, election petitioner, the respondent. And also heard Mr. D. Mujumdar, the learned senior advocate, assisted by Mr. T. Tagum for the respondent, applicant, in bracket quotable in IA, to IAC 214/2024 and IAC 240/2025.
Yes.
Let the as agreed by both the parties, let the matter be listed on 20
Yes.
November 2020. Okay. then.
Lordship may kindly, if your Lordship so desire, Lordship may fix it at 2 o'clock so that in the meantime, in the first step, Lordship can finish your Lordship's other matters. 2 o'clock we straight away start arguing, madam. 2
Okay,
o'clock.
at 2 p.m. Okay, we'll see. Okay.
Hope my learned friend doesn't have any objection. No, if fixing at 2 o'clock, it
Not
becomes
at all.
convenient.
He will
In
not
that case,
object.
it becomes convenient for the court also. Oblige me.
Yes, for what the party is actually.
Item number 30.
Ah, 2011.
Item number 30.
You are in item number 30
Yes, Your Honor.
for the petitioner you are appealing?
Yes. Your Lordship, matter may be fixed on next date.
Next?
Next date.
Next
Next date. Yeah.
Next week? Acha. You are Mr.
Tinima.
Heard Mr. Tinima appearing for the petitioner, non-appearance call for the respondent. Let the matter be listed after a week as an date to be fixed by the registrar. Okay.
Obliged.
Matter is over.
No, 34 is there.
34 is already disposed.
Huh?
It's already disposed.
Oh, sorry.
Yeah.
It is already disposed. Do one thing, there will be record will be dispatched. No, you write the names of particular names of the councils appearing for all those cases.
Yes.
And the respondent, most probably these two are there, Arsakia and then Mr.
Dilaji.
Hmm?
Dilaji was also there.
Dilaji was also there. Dilaji for whom? No, Dilaji was not there.
Yeah, Dulaji also was there for petitioner in this item number 18. 18.
Those petitioners name you write, the council for the petitioners.
Yes, sir.
Okay. How do it is kitna bada record hai?
Itna bada record mein I have done the stapler also. I have given all the names and
You are from Assam. You
I'm from
practice in
Nagaland.
Guwahati.
Yes, Lordship. But
Okay.
Lordship, in this item 27, it will not be compensation. It will be pending bills. If I'm not
Pending bills.
Yes,
Oh,
bill
sorry.
payment, yeah.
You have right the dictation. You have taken dictation on item number 27. Pending bills. Pending. Oh, pending bills. Sorry. It was a pending bills.
एक line ही बोलेंगे. So, my lord, I have come with my written argument.
Okay.
It is refined, and my lord, I have indicated the paragraphs. And yesterday, somewhere I might have mentioned the wrong paragraph.
Yes, that is also recorded by us.
Yes.
This paragraph, the judgment which you have provided.
Either.
We have already. Yes, one list of things is also there.
Yes, my just I am giving it.
Okay.
I took Santosh did it. But only one paragraph where yesterday I missed a line that I'll just, if my lord permits, I read out in 2 minutes.
In which
my lord will
judgment?
kindly come to page 7, internal page 7, ground 4.
Internal page 7.
2.5 page, my lord. That this is very important for me. It seems when I read. Broken chain of custody and contradictions between medical and ballistic evidence, forensic evidence unreliable, my lord. PW16 FSL scientists impugn judgment para 32 page 88 and paper book 88 cross-examination admitted during cross-examination that he did not receive the actual bullet that killed the disease for examination. This is the most critical missing link in the prosecution case. While the empty cartridges was matched to the recovered rifle, the absence of the bullet from the deceased body for the forensic comparison leaves a fatal gap in the evidence directly linking the specific bullet that caused the death to the recovered weapon.
PW 15 investigation officer further admitted that he did not find any pellets at the place of occurrence. PW 14 medical officer stated that no bullet was recovered from the deceased body. Despite this critical lacuna, the learned trial court in paragraph 46 at page 28 of the impugned judgment paper book 97 erroneously concluded that the recovered rifle was murder weapon, which finding is wholly inconsistent with the evidence on record. But PW 15 admitted the following critical omissions: did not seize the clothes of the accused, potential gunshots, residue evidence lost, did not forward the firearm for fingerprint test, no link between accused and weapon, did not annex his forwarding letter when sending the exhibits to the forensic science laboratory. Exhibits were once returned and later resent. Chain of custody broken. A sketch map claimed to be prepared is missing from record. No disclosure memo prepared, no arrest memo prepared, and no independent witness associated during search/seizure, my lord. From here, my lord, it is very critical, including the highlight portion, my lord. PW12, during his initial deposition before the court, failed to disclose the factual crucial fact that the convict had taken the murder weapon from him and allegedly used it to kill the deceased, page 57 of the paper book. However, after PW13 testified that he was the actual owner of the gun and had left it with PW12 and stated that he had no knowledge of how the convict used the gun to cause the death of the deceased, page 58 of the paper book, PW12 subsequently appeared as court witness 1 and disclosed information about the gun for the first time, that is page 57, my lord, I have indicated. The testimony of PW12 as CW1, court witness, appears to be an improvised statement designed to conceal facts he had deliberately withheld during his initial deposition as a prosecution witness. Moreover, PW12 as CW1 specifically stated that he was not an eyewitness to the incident, and B, it was possible that someone other than the accused could have fired the shot. My lord, the highlight portion, my lord, this is important. The statement of PW12 as prosecution witness are materially contradictory to his subsequent testimony as CW1. These vital contradictions have not been properly appreciated by the court below while convicting the accused. Significantly, PW12 has failed to disclose whether he handed over the gun to the appellant, convict or not, thereby raising a reasonable possibility that PW12 himself might have killed the deceased in this case, my lord. This is, I want to project it, my lord. Just the small paragraph, I will conclude, my lord. PW16 medical examiner opined that during examination, he found one entry wound of a bullet on the right upper back of the deceased. He further observed bruising on the forehead, hematoma below the right lower lip, and a small cut injury on the left eye. Significantly, PW16 found no pellets inside the deceased's body and concluded that a puncture wound may possibly have been caused by a weapon other than the one alleged. This medical finding directly contradicts the testimony of IO PW15 and PW8, who stated that the accused took a .35 rifle, which he kept with him after returning from jungle, fired one round in the air at his house, and then proceeded to entry point at Koina. According to their testimony, when a person approached him, he believed the person was coming to snatch the rifle. As the person come closer, he fired upon him, but could not recognize who that person was. Page 7, my lord. My lord, here, my lord, kindly see, there is one legal word, bis measure. So these bis measure means by the act of God, my lord. I just forgot the exact provision in the CRPC, I can find out. So these might be the cause also, one cause. The medical evidence thus raises serious doubt about the prosecution version of events and weapon allegedly used, which have not been adequately considered by the learned court below. Such lack of a verified chain of custody renders the forensic opinion unreliable and inadmissible. Those These omissions break the evidentiary chain and render the forensic evidence unreliable. The FSL report matching Curtis to the rifle has no relevancy, no evidentiary value because chain of custody broken, exhibits returned and resent. Fatal bullet never examined, no direct link to that, no forwarding letter, cannot verify what was actually sent. No fingerprint on weapon, no link to accused, and no GSR testing on accused clothes, opportunity lost. Mano, here the law is, in this case, the law has been settled. It is well settled in the Dudnath Pandey versus State of UP, 1981 2 SSC, page 166, paragraph 15, that recovery of a gun at the instance of the accused by itself cannot prove that accused wielded it for the offense, and the ballistic expert merely showing that the shot which killed the deceased was fired from the gun pointed out by the accused also does not by itself prove that accused used that gun in committing the offense. That much only I want to make a submission. Last paragraph is, coupled with the medical officer's statement, but no bullet was recovered, the prosecution's theory collapses. The prosecution cannot prove beyond reasonable doubt that the recovered rifle was murder weapon, the accused fired the weapon, or the weapon was handled by the accused. The forensic evidence is incomplete and unreliable based on broken chain of custody, missing the most critical link, fatal bullet, and cannot establish guilt beyond reasonable doubt. I'm grateful, my lord. Only this paragraph I want to read it out. Citations. My lord, and the rest of the citations I provided.
Yes, Mr.
Yes. Your lordship, his trial was concluded and accused was convicted for under 302 IPC and 27(1) of Arms Act. I like to, your lordship, I humbly pray before this court that I may be allowed to revisit some of the relevant documents in the paperworks.
Yes, sure.
Though learned counsel has already. This is a case convicted under circumstantial evidence. There is no eyewitnesses, only purely based on circumstantial evidence. But there is a presence of independent witnesses. As per FIR, offense was committed at 8:30 p.m.
9:30.
No.
See, 8:30 to 9:30.
Yes, in between 8:30 to 9:30. On 1st July 2020. And here, the improvement in FIR is younger brother of the deceased. He was not present at the time of incident. He was residing somewhere 6 kilometers away from the place of occurrence. Yes, there is delay of 12 hours registering of the FIR. But police visited the place of occurrence immediately within half an hour when they were informed by some locality of the vicinity who were residing in the vicinity of the place of occurrence. There was a check gate nearby place of occurrence from where outsiders and villagers used to exit and enter in that place. And there was, as per 161 statement, it was not brought in the deposition of any other witnesses, but in charge sheet, it was reflected. And depositions of deed and investigation officers, deed and. Here, Your Lordship,
Regarding the entry gate and exit gate.
yes, the purpose for this erecting entry gate to contain this pandemic COVID-19 from spreading in the place, so that they formed the committee to check the persons and goods who enter from the outside and to sanitize them as per the SOP norms. That's where they deployed for some 4 persons. This was at that relevant time was deployed in check gate, and the rest others were in the camp, their camp, nearby that check gate. That is hardly 10 to 15 meters away from that check gate. Here, Your Lordship, circumstances, what led to circumstances to convict is that these convict persons were seen by the brother of deceased, elder brother of deceased, whose residence is nearby the check gate, saying that this convict was going toward that check gate, stating that I will kill. That sound was he heard.
Is PW?
His PW1. PW Tasi string. It's in page 44. Just I will read relevant portion only. On oath in chief, I'm appearing as a witness in connection with murder case of my elder brother, that means his younger brother of this is Nobu Kashido, who said this is. I know the accused person, San Norbu, standing on the dock. He is one who killed my elder brother on 1/7/2020 at 8:30 p.m. by gun. At that time, I was at my home. I heard the voice of San Norbu Saidu, who is a convict here, saying that I will kill. At that time, he was carrying gun on his shoulder. After a few minutes, I heard the sound of fighting. When I came out, I saw that my elder brother was killed. That is his version in chief. And when he was put into cross-examination, it is fact that there was no prior enmity between the deceased and the alleged accused. Yes, of course, he was not an eyewitness, but he clearly stated that he saw the accused person going toward the gate, carrying gun and shouting, "I'll kill." And he know him personally because they are from same villager. I'm going to some other deposition also. Then, Your Lordship, PWD2. In his chief, I'm referring in such a case in connection with such an incident. At the time of incident on 1/7/2020, I was president of certain student union, and we were on duty of COVID-19 at Sidal Place. That check gate was located at Sidal Place, entry point and exit point. BCS was on duty with us. They were the committee who were deployed to monitor the COVID SOP. I know that this is Nobu Kashido, as he was from my own place. I also know the accused as he is also from my place, but he was not on COVID-19 duty. He was not a member of that committee. The incident took place near the gate, At actual time of incident, we all were in our camp, but the disease was near at gate. We heard the gunfiring and came to the gate after 10-15 minutes of the gunfiring and noticed the deceased was lying on the ground with bullet injury. We informed the villager and police. Thereafter, police came and took the dead body. This witness was declared hostile because this is a witness who stated under 161 before the police that there was a meeting comprising of head of the blaze, so elders of the blaze and other public to monitor the check gate in regards to the prevention of COVID-19. And this student president, union president was also made as a member to that committee for monitoring. And on cross by PP, after declaring hostile, it is a fact that all the process of SOP and its protocol of COVID-19 were maintained properly. It is a fact that gate was erected and 3 to 4 persons were detailed to monitor the incoming and outgoing people and their goods. It is a fact that the incoming people and their goods were properly sanitized and returnees were kept under quarantine as per the admissibility. It is a fact that in meantime, it has come to know that on 24/6/2020, at around 4 p.m., one Sang Norbu Saidu, this is a convict, has come from Dirang and entered into his house at Sidal Blaze without the notice of anyone in the blaze. This convict was outside for some days, and he returned back in his own blaze, not from the main gate, somewhere from the backside of route, without letting them know that he already entered into this place. It is also a fact that he did not enter through the place of entry gate Sidal. It is a fact that on inquiry, Sang Norbu Saidu admitted that he came from Dirang after hunting animals in the jungle of Tembang and Santi and gets entered into the house from the backside of the village, concealing himself to get rid of the committee members' rule and regulations. Thereafter, it is fact that committee members decided to keep him in home quarantine and explain him the protocol to be followed. It is fact that he cooperated with us. The villagers have done their level best to look after him by visiting in his home. That it is a fact that he did not raise why he was quarantined. It is not a fact that he has to go outside for earning for livelihood. That means he was not allowed to go outside. But he was found roaming before his quarantine period was completed. It is a fact that before completion of his home quarantine, Sang Norbu Saidu has gone to place of entry gate and gunned down one Dabu Kasidu on 1st July 2020 at around 8:30 p.m.
So while cross-examination, he rather admitted.
Yes, by PP. He elaborated his deposition in chief. After declaring, he elaborated the real fact, actual fact.
Yes, at the time of cross-examination by PP.
Yes, by PP.
My lord, I am sorry, just when this cross-examination, there cannot be elaboration. Only whether you have to deny or admit.
It is a, Your Lordship, it is a rule.
It's not the case.
It is a rule. Even after declaring of witness as a hostile, the statement portion which favors the prosecution has to be admitted. It is a settled law of the principle of the law.
Yes, it is.
Yes. So here he elaborated a little more. Why and under what circumstances he was put into quarantine and he was seen going toward
the entry gate.
Yes, near the gate. And this was at that point of time was deployed near the gate. Then Your Lordship, PW3. This is evidence after this is evidence who heard the voice of accused who committed the offense after the commission of offense. PW1 is one who had prior to the commission of offense, and this is a person who had voice after commission of offense. Here you are see his PW6-3. I'm appearing in such a case as a witness. We were on COVID duty at Cedar Blaze Gate from 6 a.m. to 4 p.m. During the time of incident, I was present at camp, which is distance of 10 to 15 meters from the actual PO, place of occurrence. It was at around 8 to 8:30 p.m. After hearing the sound of gun firing, we were quiet for a few minutes, and we also heard a voice of accused stating that "Hum marega bolne se marta hai." That means in simple English language, if I say I will do something or kill something, then definitely I will do it. It's something like that's a simple meaning of this universal. However, I have not seen the accused.
Salman Khan. Like Salman Khan. Yes.
However, I have not seen the accused, but as a blaze below, I could recognize his voice. They are from same blaze. After a statement in loud voice, the accused went toward Jirigaon side. Jirigaon South is general site of the this check gate.
Check it.
Later on, we went to the PO, and the deceased was already dead. This is a statement, the position under oath testimony. In cross, it is a fact that I have not seen with my own eyes the whole incident. It may be possible that the gunshot may be fired by some other persons. However, since there was no other person roaming in the night, I believe that the accused was the person committing the offense. He affirmed his testimony in chief in cross also. He believed because he is a blessed below, he can never made any mistake to identify his voice. Yes, recognize his voice. It is a fact that a person is not necessary to reveal his act of commissions of offense by shouting out the fact of the case. This is her assumptions that yes, that maybe not be there also, but he reaffirmed his testimony in cross. And here, in 161 statement, this PW2 clearly states that they, in charge sheet also, prior to commission of offense, this is an accused were together and had a local wine also. Thereafter, this is left for a duty, and he come afterwards. This accused having guns after drink. So this is a accused to statement by shouting prior to and after the commission of offense. And fourth one is also a member of that committee who was also stay in the camp on that time of incident. No. This is one who came across and meet the accused on the way.
Who? Which one?
This accused, PW4. Jambong Rongradu. On oath, I'm appearing in this case as a witness. I know the accused person is standing in the dock. I do not remember the date and time when I came across with the accused at Siddle side in one evening when I was coming towards Blaze and the accused was going toward Siddle side. The accused was having a gun in his body. This is an independent witness. When I asked him where he was going. He replied me that, "Tum bhi chahiye hai kya? Do you also need?" That's an, matlab, this is after the incident, when they meet each other on the way to Sidal. We are from same place. Later on, in the same evening, I heard that this is Dobo Kasidu was killed by the accused. That means earlier he said he did not remember the date and time, but later on the same day, he came to know that this is was killed. Cross, it is. He admitted that he was not an eyewitness. Now it's PW5, Monjan Kasidu, page 49. He say he's a brother of accused person. His own brother of accused person. Elder brother. He is also a hearsay witness because he was only informed. But one here important point is that he admitted that accused is his younger brother. On date of incident, that is 1/7/2020, I was at my home. I heard the sound of gun firing from the side of Sang Norbu Saidu's house. Actually, there were two gun firing guns. One at his accused residence itself, first firing, air fire, and second was directly hit to the deceased. That was the contention of prosecution. What I was made up from all these evidences. I heard the second time gun firing from Sidal Gate for COVID checking. I had a doubt that the Sang Norbu Saidu has fired the gun. Here, it is an important point that his own elder brother has doubt that his younger brother has shot that gun firing. Accordingly, I informed OCPS Napra. After 10 minutes, I went to the PO. There I saw the dead body of the deceased. Blazer told me that accused was having gun and went toward Jerigao side. After committing the offense, this accused went to the Jerigao side, which is a jungle area. Later on, this place will be described. And accused was apprehended after 2-3 days of the incident from the jungle by the police. That means 2-3 days, accused was absconded. Here, Cross, it is only try to establish that he is a hearsay evidence. PW6, who has lodged an FIR, younger brother of deceased. He is also a hearsay evidence because he was not at the time of at the place because he was somewhere staying outside of the place. And when he came back, he was informed by Sang Dorji Kasidu, Arun Matadu, Takar Rangradu, Asis Ring Kasidu. That means 4 accused with 4 other members. Sorry, this is with 4 other members. These 4 members, other members were together informed him about the incident. Thereafter, I lodged complaint at OCPS Napra against Sang Norbu Saidu. I know the person standing in the dock. He is Sang Norbu Saidu. We are from the same place. This is an accused also from the same place. All are same place, except these official witnesses. He was informed about the voice of accused heard by the other witnesses, by the dead widows. In defense, in cross, it is a fact that I am illiterate. It is a fact that I have not drafted the FIR myself. So, police station is located somewhere, Blaise is locating somewhere. He finally reached Blaise to find out the fact and to know the situations. His brother was found already dead, and it was nighttime also. And he was illiterate. FIR has to be write down in written form. So he might take that time to lodge complaint in the morning of the 9 a.m. of the next morning. That means there is a 12 hours delay. But police was informed
Immediately after.
yes, immediately after the incident came into light. PW7 is also a member of that committee. He also heard a shouting voice of the accused just above their camp, stating that Marega bola hai to marega. He's also a witness of this statement of the accused. Thereafter, it is also written. After some time, we came to know that the deceased was killed by bullet injury, and the incident was reported to police. I saw one live cartridge and one empty cartridge at place of occurrence. He is a seizure witness also. From spot, one empty cartridge and one live cartridge was recovered. And this will corroborate the findings of a FSL expert. Here, it's PW8. PW8, P. Rijuji was a OC at the time of incidents. At the time of occurrence, he was a OC of OCPS NAPRA. He put his signature in the charge sheet and submitted the final report. But his deposition says before putting his signature, he was already retired. Because they are in the that's a part of the record also. But here there is a depositions of first IO, whom this PWD then OC endorsed as a IO of the case.
Yes. Sarma. PW50.
Page 61, 62, Laxman Sarma, PW15. Itu 61. 17. What is the last PW you're reading now? PW, which PW? Last one. It's 52. He was didn't OC PS NAPRA. But this PW 15. This OCPS NAPRA endorsed this SI as a IO. And FI itself, when FI was received in written form.
Correct. PW8.
8 and those 15 as a IO of the case. May I read from second para? During investigation, I have visited the PO and drawn rough sketch map. I have examined the informant and other available witnesses and recognized their statement, recorded their statement. I hold inquest over the dead body. This is Dobu Khasidu in presence of witnesses. I have recovered one empty fire cartridge and one live cartridge from PO. This corroborates with the PW 6. PWD. One second, Your Worship. Yes, PW 7, who stood as a seizure witness. One empty cartridge and one live cartridge from the spot recovered. Thereafter, I have forwarded the body of deceased to CSC Napra for conducting PME. After PME, the dead body was received back and handed over to the relatives of deceased for performing last rites. I have conducted such. It should be not such. It should be typographical mistake. It should be search in and around the PO. That will make some corrections. Search in place of such. 62 first line. Around the PO. That is Seidel/Hoina. And later on 3/7/2020, the alleged accused Sang Norbu Saidu has surrendered before me. Firstly, accused fled away from the scene spot, evaded and absconded. After that incident is 1st July, on 3rd he surrendered himself. And from PW 8, who is D then OC, he was apprehended from field, some field located in
Jungle, from the jungle.
in Lower Jang, Alubari, field at Lower Jang, Alubari. This PW8 also went along with eye of the case. Then the PW13, this IO. Sorry, 15, PW15 IO. Thereafter states that I have arrested the accused person, and as per his lead, the weapon of offense, that is .315 rifle with 13 round live cartridge was recovered from jungle in between Napra to Nahu roadside. Their weapon of offense was recovered on disclosure of the accused persons and led by the accused persons. Accordingly, I see the same in presence of witnesses. Here it is also a fact that there was no civilian in and around that spot where seizure was made. Police personnel were 3 police personnel, including DSP, were that seizure witness, part of seizure witness. I have forwarded the weapon for FSL examinations. After that, I again conducted the search for ascertaining the owner of the weapon. It was found that the weapon is belonged to one Sri Dongrik Miji. I have seized the license of gun from the Dongrik Miji. I have also arrested Dongrik Miji and forwarded him to court. Thereafter, I was transferred out from the Napra PS, and accordingly, I have handed over the case diary to OCPS Napra for further investigation. This first IO did not complete the investigations. Prior to that, before completion of the investigation, he was transferred to some other place, and he handed back to the OCPS Napra, who endorsed him for conducting investigation as an IO. For further investigations. And charge sheet was cited by lead and OC that in charge sheet in page number 7, charge sheet, page number 7, last para. All other earlier investigation was done by this first IO, but last para of the page 7 is an investigation part of further investigations. Findings during the FSS report has been received from Director of Forensic Science Service, MHA, Government of India, Urput Blaze, Urput Kumeria Road, PO such and such, Tinali Palasbari District such and such, Assam, through SP Bomdila, wherein AK Pal, scientist ballistic, has opined that 1. Exhibit A was used for firing some time before it was received in the laboratory. 2. Exhibit A is a regular .315-inch caliber sporting rifle manufactured by Indian Ordnance Factories. It is in a working order in its present condition. Test fire conducted successfully. 3. Exhibit ECI is .31-inch /8 mm caliber empty cartridge case, and it has been fired through Exhibit A. Exhibit A is a weapon of offense, that's a gun. This is a finding of forensic report, which is reflected in the charge sheet. Exhibit LR2 and LR4 were found to be in live conditions before test fire in the laboratory. The remaining cartridges marked Exhibit LR, L3, and L5. These are the sample L1 to L5, LR5 are the live cartridge, which was seized along with the weapon of offense, that is gun, from the jungle. That was sent for FSL report. This LR1 and LR4, LR3, 1, 3, and 5 resulted to misfire through Exhibit A. 5. Exhibit A is a firearm. Exhibit EC1 is a part of ammunition, and Exhibit LR to LR5 are ammunition as defined in the Arms Act 1959. Here, Exhibit LR2 and LR4 were found to be in live condition before test firing in the laboratory. And it was, result was similar. That was Exhibit EC1, ECI, that was empty cartridge. Then, Your Worship, this detailed OC, after receiving of the FSL report, during the further course of investigations, he submitted a charge sheet along with this FSL report. And rest other investigation was done by the first IO himself. Only because of the transfer, before concluding his investigations, he was unable to
brought after the retirement to sign or to conduct.
It is his deposition that he was called after the retirement, called back after the retirement.
Signature.
Yes, to put the signature because most of the part investigation was done by him in the monitoring of him.
Signature and prepared.
Yes, it is his depositions. I will not go beyond the record. I will not only.
No, no, okay.
Then this is the case why this charge sheet was signed by the circumstance situations were called back again and to put his signature because he has conducted and concluded the investigation to reduce it into charge sheet. So that may be the reasons. Reason was not clearly specified why he was called back. And before coming into postmortem report, I would like to take your worship to the positions of PW 15, 16, page 64, Sri Arun Kumar Pal, who is a forensic scientist. Yeah, I will take yourself to the specific findings in page 65. This portion was reflected in the charge sheet, which correlate with each other and tallied with each other. On the basis of result of examination, it is opined that 1. Exhibit A rifle was used for firing sometime before it was received in the laboratory. 2. Exhibit A rifle is a regular .315-inch 8 mm caliber sporting rifle manufactured by the Indian Ordnance Factory. It is in working order in its present condition. Test fire conducted successfully. 3. Exhibit EC1 is a .315-inch 8 mm caliber empty fire cartridge case, and it has been fired through Exhibit A rifle. 4. Exhibit LR2 and LR4 were found to be in live condition before test fire in the laboratory. The remaining cartridges marked as LR1, LR3, LR5 are resulted in misfire through Exhibit A. Next page. 5. Exhibit A is a firearm. Exhibit EC1 is a part of ammunition, and Exhibit LR1, LR5 are ammunitions as defined in arms act. After completion of my examination, the exhibit remnants of exhibit mark as Exhibit A, EC1, and LR1 to LR5, along with original packing covers, have been packed in one cloth parcel and sealed with seal impression of ballistic AKP CFSL GHY, given below in my report, such and such number, and returned to the forwarding authority. Here, and when we peruse the original report of the FSL, that is in page 2022.
Page?
20 to 22. The report.
Yes.
Actually, it starts from page 19. Sorry, 20.
My lord, I take back leave for 2 minutes.
Okay.
Welcome back.
Here it is tallied with the depositions of PW.
Those, from his report only.
Yes. And opine that it cannot be ruled out that that cartridge was used from that firearms.
Yes.
It is there in the report also. Then, Your Lordship, injury over the body of deceased. That is, we will come to know from postmortem report. That is in page 17 to 18. These all are official witness, so they will not part of their own reports. Page 18.
PM report.
PME, postmortem report, page 18. That is from middle person, this column 5, muscle bone joints. That is about a specific injury. First, case hematoma at lower lids. Report, it's absent. 3, fracture scapula. Dislocation absent. Then there was no any other injury. But opinion of the assistant surgeon, sub-assistant surgeon down below, more detailed description of injury or disease. On examination, an entry wound measuring 1 centimeter into 1 centimeter found at scapula and induration around wound measuring 7 centimeter into 7 centimeter. 2, exit wound was elongated in nature and found at gipisternum measuring 3 centimeter into 1.5 centimeter. Then comes opinion of assistant surgeon, sub-assistant surgeon as to cause of death. On detailed examination, I am of the opinion that the person died to puncture of lung caused by bullet injury. That is puncture of lungs caused by bullet injury. And this opinion was corroborating with the findings of empty cartridge on the spot and other PWs who saw the accused with a gun running around the place of occurrence at that point, at 11 points of times, and that intimidating voice, which was heard by the other people residing in the vicinity prior to the incident and after the incident, which is corroborating with each other's of the incidents, fact of the incidents. Yeah, the doctor also in the position only that reporting the postmortem report only.
Doctor was PW 14, na?
Yes.
Doctor was PW
Yes,
14.
PW 14. And 15 is was IO.
Yes, yes.
16 was expert scientist. Then page 67.
Just. It's not something can be possible, but there can be issue.
Yes, page 14.
Yes, page 14.
Yes, page 14.
Huh.
It's a seizure list. It's a seizure list. Weapon offense was recovered on being led by accused Sang Norbu in connection with this case. Rifle number described as AB 05 1499 4 315 within bracket with its starting nose round live cartridge. Then name of the seizure witness is first SIP Rijuju, who was the then OC. Then second was Head Constable TT Suniraje. Their signatures were already exhibited before the court. Then 3, Constable B Likhambi. Then 4, I Lolen. His designation is not there, but they are all police personnel. In their depositions, they disclose the name of DSP also, who present in the spot at the time of all this seizure witness disclose the name of DSP of the Bomdela police stations. Napra pulls under the Bomdela PS. That is PW. These witnesses are PW 9, 10, 11. Yes, 10, 11, 12, and PW 8. Seizure witness 2, exhibit 2. Oh, sorry, exhibit 6. Exhibit 6. This is a recovery of weapon offense. In one of the memorandum ground of for the appeal in the memorandum of appeal, that is how gun came in the hand of this accused. This was explained by the court witness 1, court witness. His name is Lekhi Sange. Lekhi Sange, on court examinations under oath, he deposed court witness 1, only one court witness.
But probably he is also the court PW 12.
Yes, he was examined twice. On oath, I know Dongri Miji. I happen to meet PW 13, who is the actual owner of this gun. License is in his name and in the name of PW 13. At Jirigaon and took his gun, which is the weapon of offense in this case. Around 2 weeks prior to the incident, I, along with the accused and some other persons, went to hunting at Munna camp area. After hunting, the accused asked the gun for hunting for 1 or 2 days. I gave him the gun, belongs to PW 13 for hunting. In this way, the weapon of offense came into the hand of accused. I know the accused for last 2 years back. Metal exhibit 2 is the gun belong to PW 13, which I have handed over to the accused during hunting, but I do not exactly remember the exact date of handing over the gun, but it was around 2 weeks before the incident. I came to know about the incident on the night of the incident, but I was at Bomdila. On cross, by defense, in fact, the gun was with me long time back before the PW 13 came to purchase of cow and bulls. On that day, he was supposed to take back of the gun, but due to business, he forgot to take the gun with him. Hence, the gun was in my continuous possessions and lockdown came into effect. It is not a fact that I have not handed over the gun to the accused. It is not a fact. That means he handed over the gun to the accused. It is a fact that I'm not eyewitness of the incident. Yes, he was not eyewitness. It is possible that some other persons other than he's not an eyewitness, so he become a hearsay witness of the incident. Only he heard from some other persons. And this PW PW 13, who is the owner of the gun, weapon of offense, his deposition is at page number 58. He was also arrested in for irresponsible holding of this gun license by giving his gun to other persons. On oath, I'm appearing in this case as I am the owner of the rifle bearing license number such and such. My gun license was seized by the police in connection to this case. I am from Salang village under Lada circle of East Kameng district. On occasion, I came to Napra to purchase cow and bulls along with my relatives, cousin brothers in order to perform local rites. We purchased one cow and same was brought back to Lada. However, on the way at Jerigao, we rested in the house PW12. On reaching back to Lada, I realized that my rifle was not brought back. After that, I made inquiry to PW12 about my rifle over telephone. He told me that the rifle was in his safe custody. I got suffering and did not come to collect the rifle. In the meantime, the nationwide lockdown was declared. After a few months, I heard that an offense was committed from my rifle. I do not know. The accused is standing on the dock. Exhibit, this gun license was seized, and there was a witness also, independent witness also. And these persons handed over the gun to PW12. And PW12 handed over the gun to this accused for hunting purpose, only for 2-3 days. Prior to the incident, that is 2 weeks before incident. So position of gun is not disputed. Position of gun by accused at the time of incident is not at all in dispute. He possessed that gun.
Disputed by them. It is disputed according to you. It is.
No, upon depositions, it can be safely. It can be safely presumed from this 12, 13, and then thereafter this PW1, and by his own brother, PW3, and recovery of the gun after disclosure statement of this accused. This from their depositions and this findings of the guns recovered from the guns from the this knowledge of the victims, accused. This is only conclusive piece of evidence that gun was possessed by him, by accused only on that point of time. Now, accused in his 313 CRPC is
denied all.
Yes, of course, he denied all the incriminating question put to him. But in one question, that is in page is 34 to 43. 34 to 43. It begins from 34, page 34. Page 45, Your Lordship. Oh, sorry. 34 to 43. 1 second. Page 43. He denied all questions, of course, but in this second last question, in page 43,
Yes.
do you want to say anything in your defense? This is also a question.
Yes, yes.
He gave reply, during the period of incident, I was at my home and two persons, namely Rakupu Deru and Paji Deru, came to my home and they were with me. This is a plea of alibi, something like that, but he was not at the spot.
And these two, this Rakopo Daru and the Paji
were with him
they were
at
also
his
the-
house. Yes,
examined at the DW and
highest DW1 and 2. Now I come to the DW1 and 2 depositions. DW1, page 68. Is one Grapodu Deru. He was only summoned to appear before the court as a DW1 only because that he is a relative of accused. And he only on that is only he gave a statement that he knows him during the period of COVID pandemic. He used to supply some eateries and all to him, and nothing else that he was.
and that is also not disputed. I think he was, in fact, was in home quarantine.
Yes.
He was put under home quarantine during that period. I mean, he went outside through jungle. There, these are other.
Yes. Accused was under yes, under home quarantine, and as per CS charge sheet, earlier this committee was directed him to go for quarantine for 3 days. Later on, it was enhanced up for 5 days. He became frustrated, and he got anger also on the decisions. Thereafter, in the meantime, before completion of the quarantine period, he went outside from his house and went toward the gate with this gun, and incident took place. This is a complete chain of circumstances which knit together, which link is without any broken, linked together and clearly pointing against the accused as the main perpetrator of the crimes. This all evidence, epistle, and there's and other witness, independent witnesses, and medical evidence, opinion that injury was caused by the. It was no pellet was found as contended by this our learned counsel for the appellant inside the body. If there is a close range shoot, then nothing happened inside. Doctor clearly opines that it hit from the backside. Entry point is in the backside, and exit point is in the lower part of this lungs. From chest, exit was there. That means nothing will remain inside the body. Of course, pellet was not found by the IO, but empty cartridge was found. This cover of the pellet. So that is all material evidence which is against the accused only, not against any other persons. And this DW2, Pali Deru, whom accused says that he was with him at the time of incident. Page 69. Here, this is a very interesting depositions. It was cross-checked by GP on oath by defense on the 69. On the date of the incident, I went to the residence of accused person and met at his residence. I do not know about his involvement in the present case. I went to the residence of the accused in the month of June 2002. Incident took place in July 1st April, July 2020. I went to the residence of accused. It was 20th June of 2000. Here he reaffirmed his earlier statement in chief itself. Then PP cross was done by PP to check his memory. It is simply to check his memory. I do not know anything about present case. I know today's date. It is September 2023. And it was recorded in September 2023 by the Lanet Session Court. That means he was quite aware about the date and month and year. But in chief, he repeatedly says it was in 2002, in the month of June. June comes prior to the, of course, July. That is much earlier than visited. Of course, there may be some visiting part on from to the accused house, but not at the time of incident. They were together. It is not disclosing any such things.
Okay, once it said that I went to the resident of the accused in the month of June.
June
2002 or whatever, it may be mistake there.
2000.
And I went to the resident of the house. It was 28 June, specifically stated.
Yes, June 20. And on cross, he says, yes, I know today's month and year. This is September 2023 when this deposition was recorded. What I mean to say is that his memory is not so dull. It's good enough to remember that. Yes, so this is all about the fact of the case, where circumstances, link in circumstances are closely knit together without any broken link. And it clearly points out against the accused, present accused, who is convicted for 302. Section 27(1), using of arms without license. And in judgment, it also justifies and with a reason that this present convict may be convicted under Section 25 also for possessing arms. But here it was using of arms to kill the persons and to convict under Section 25, possession sanction is required. That was not there. But to convict under Section 27 for using of unlicensed arm without using without license, that part the criminal
Stapler. Okay, these are all facts.
I've been served other judgment not relevant to this case, but one judgment, one copy only is there. I may refer the citations of the case. Otherwise, two more copies for honorable judges there in the office. My clerk did not bring that one.
No worries.
Instead of get some other
Okay, provide the judgment.
citation. Citation is there. This is regarding Supreme Court judgment, criminal appeal notes 339 to 340 of 2014. It is reportable, but I have some online printout.
Just repeat again.
Criminal appeal number 339 and 340 of 2014. Parties name are Rajesh Yadav and another, etc. appellant versus State of UP.
What the judgment says?
Judgment discusses about the relevancy of provisions under Indian Evidence Act. It's all about hostile witness, when it can be, which part of the statement can be admissible and not admissible. Then thereafter, it says about appreciation of evidence. Category here, this just judgment. Then
If you have one copy, extra one copy you have, do we have?
yes,
No, now at present, how many copies you have? One copy. One copy. Oh, only one.
yes,
you
I'm
only-
referring this with by this copy.
Acha.
Yeah, evidence below final report was discussed. Evidence below. That is for corroborations. Final cannot be ignored also. Final report, that is charge sheet, wherein 161 is also along with charge sheet. 161 also enclosed with, and 161, though it was not directly admissible, but that can be put as a contradictory and corroborative part also.
Corroboration part.
Yes, to declare hostile, 161 has to be compared with when the position is made. I'll supply this copy. That is already ready in the after.
Okay, so.
So this is a name by Rajesh Yadav and another versus State of UP in the year of 2014. Criminal appeal number 339 and 340. So with this, yourself, I like to conclude my submissions with the prayer that every evidence on record is pointing only against the accused and none other else. Though it is a circumstantial evidence, when it is the link is so connected, so linked together, knit together, it can be basis for convictions. So my humble prayer before this court, though there is some procedural lapses there. No, I accept. Even with without my acceptance, you yourself may find it out. There is a procedural lapses there, of course. Minor discrepancies in investigations, especially in procedure part, may be overlooked in the serious offense like this, where death was caused with the intent. Intent was very clear, much clear. He was prostrated at the time of COVID for putting him into quarantine, and he violated the quarantine norms with in a prostration mood and with an anger by shouting, "I will kill, I will kill." That means clear intention was there. Knowledge was there by shooting person from one gun from so close range, where even pellets come out from other side of the other part of the body. Then definitely he has knowledge that he was also a hunter, how to shoot the animal and to cause death on the spot. So he has knowledge of that incident, that part of incident. By shooting, men will definitely die. Knowledge and intention is the main ingredient of Section 300 IPC. So my humble prayer is that to uphold the convictions in this case. Highly obliged.
Yes, informants.
My lord, since all the points have been covered by, my lord, since all the points have been covered by the learned PP, I wouldn't repeat the same thing, but 2-3 points I would like to place, which my learned senior has contested, my lord. My lord, there is no doubt that in a circumstances evidence, my lord, we need a body and ammunition and the murderer. Who is the murderer? There is no doubt that the person was murdered or killed by a .315 rifle. A dead body was found, my lord. Now, my lord, this person was charged, which has been sorry, my lord, the convict has been charged in 2 heads. This is in page 9. Not required also, but page 9, my lord. Firstly, he has been charged under section 302 and under Arms Act 27 Arms Act, my lord. Yes. So, my lord, here, my learned counsel has raised some of his issues. That is the signed by the retired personnel, my lord, police personnel, which is not required, in fact, my lord, and this has never been challenged in the trial court. He ought to have challenged that. Since he was the first IO, he has almost all of the most of the investigation was done by him, and the note and because of the sign, no prejudice was caused, my lord. Number 2, my lord, he has challenged that the arm which was not in the possession of that accused, convict, my lord. But, my lord, the same has never been challenged in the trial court, nor it was disputed. So, a new question of thing can never come in the appeal, my lord. Third, my lord, he has section 27, my lord, of Indian Evidence Act, my lord. It does not provide, my lord, for the recording of statement of the accused. Rather, it provides that such information received from the accused leads to the discovery of some new facts, my lord. So, in the present case, disclosure and lead of the convict .13 rifle with 15 numbers of bullet was recovered. Third, my lord, motive, my lord. It is a settled law, my lord. If motive is proved, my lord, to strengthen the prosecution on circumstances evidence, but failure to prove same cannot be fatal, my lord. Otherwise, my lord, all the points were covered by my learned PP. That is, the death was caused by bullet, which was examined by and which was confirmed by forensic report and postmortem report. And the voices, there was the voices. It was, since it is a circumstances evidence, because there was no eyewitnesses, my lord, and by the deposition of the witnesses, my lord, all the witnesses, they have said that they have heard the voice. Most of them, they have heard the voice, and there was, since it was COVID, they were posted in the entry gate, so no other people were allowed to enter or go. So in that case, circumstances evidence, there was no chain was broken, my lord. I would also like to say the accused, so the convict was also scene present in that place of offense, my lord. Apart from there are no other people were seen. These are the only points, 4 to 5 points I would like to emphasize, since others were covered by learned PP, my lord. इतना ही है तो नहीं है। आपका तो क्या है dismiss, my lord.
Well, just 2-3 minutes rejoinder. Well, I want to display this map, the place of opening offense. My lord, see, this is NAFRA headquarters, my lord. This is NAFRA. NAFRA is down below, and Saidal is here, my lord. And on top, my lord, we'll see the Jerigan. Now, this is for the reasons, my lord. PW8 at page 52, my lord. Said arrested from Alubari, my lord. The PW8 says he has arrested the alleged the convict from the Alubari. Alubari, my lord, just I was confirming through the text. Alubari is in the vicinity of Jerigaon, my lord. And this is the difference between Nafra to Jerigaon, my lord, is 50 kilometers. So they have not mentioned the place. And then, my lord, distance is 50 kilometers, my lord. Now, my lord, PW15 said arrested from Nafra to Naku Road, my lord. Now, my lord has seen Jerigaon is here on the top, and kindly see, my lord, down below is the Nafra, my lord. I don't know if this is the statement which they makes. Nafra is down below, my lord. Kindly see, Jerigaon is here, and Nafra is here. I was just working on that only, my lord. So therefore, this is one thing where
As per PW15, he is different from Jafra, Nafra.
PW8, page 52 says arrested from Alubari near Jerigaon, near Jerigaon. And PW15 says he is arrested from Nafra to Naku Road, my lord, which is opposite side, two different directions, my lord. And then, my lord, the second rejoinder. See, nahi.
When he got arrested, by the way? Incident took place on 1st of July.
July.
And he got arrested on?
Second only. Third, my lord. Kindly see, my lord, these contradictions. One place is 50 kilometers away, and another place is bottom, then opposite side of the Nafra headquarters, my lord. And police headquarters is down below, my lord. So this is one. And number two, my lord, the learned PP made a categorical submissions. The reason for calling back to sign and prepare the charge sheet was to my understanding, my lord, is to protect the PW12 only. Page 57, my lord. Who was also the court witness one. He made this statement, whom we have highly suspected, my lord, for the cause of the date. My lord, kindly ground 4, I have categorically mentioned this in the ground 4, my lord. Now, my lord will see, the learned PP has referred to the page 43, my lord. Page 43 on the 313 depositions of the accused, my lord, of the convict. Now, well, kindly have this for a minute. I'm finishing with this. Page 43. Page 43, the second last question. Do you want to say anything in your defense, my lord? During the period of incident, I was at my home and two persons, namely Rakpu Deru and Paji Deru, came to my home and they were with me. And which is clearly corroborated by PW2 at page 45. Page 45 is, who is that? Yes, I want to see page 45. My lord, kindly come to third last line. And my lord, kindly see, he is the president, PW2, my lord. He was the president of Sartang Student Union, who were on duty of COVID at Saidal Blaze. Now, my lord, seen Saidal, Jerigaon, and Nafra. There's a very far place of. Now, he was declared hostile. Now, I'm going to kindly see this last 3 lines. It is fact that he cooperate with us. That means I was, which clearly corroborates that I was under the home quarantine. The villagers have done their level best to look after him by visiting his house. And it is fact that he did not raise why he was quarantined. Huh? Huh. That means, my lord, I never, question them why you have put me into quarantine. I have to follow the COVID protocol. I have followed it. It is their own depositions, my lord. So therefore, my lord, the impugned conviction and sentence order must be quashed and set aside. It's a pure case of acquittal, my lord.
Keep it as CIB.
That's why I was looking for. Yes.
I will supply the value of it.
2 copies you have, 7? Okay, it's
My lord, that order has to pass judgment reserve at least.
judgment reserve. Very fast. I have judgment reserve.
Yes,
She knows your name, his name, so judgment reserve.
Reserve.
Pardon, your good name.
H. Jairam.
Integer.
Just that apart, we know everything. So now in a different atmosphere, you are working. I mean, atmosphere is a bit different.
Different, very different, my lord. And I am very lucky during my presidency, I could able to see the shifting of High Court building, inauguration of new High Court building, and inauguration of celebration of the Silver Jubilee.
Silver Jubilee, yes.
So my tenure is also coming to an end. Is by the grace of God.
No,
I have witnessed all this.
There will be no end for you.
I am so grateful. My lord.
You took a good initiative in our meeting. So
Yes.
I don't know, may not be. Okay, then,
Thank
thank
you.
you. Tanok tanong itu buat tangor.